that it contained a mistake. It was further put to him that these two versions are irreconcilable. Sub 17. Despite having claimed that he had stopped the vehicle, he could not remember how many people had been in the vehicle. Sub 18. He had not looked for a permit because, having recognized that the vehicle had VIPs in it, he was of the view that it was entitled to enter the cemetery. Sub 19. In fact, he had been instructed that the VIPs must enter. Sub 20. Thus directed them straight to the main gate of the cemetery because all the vehicles were entering through the main gate at the cemetery. Sub 21. He allowed the vehicle to enter because it had VIPs. If that vehicle did not have VIPs, he would not have allowed it to go through. Sub 22. He had no doubt that the vehicle was entitled to enter because it had VIPs and had to enter. Sub 23. Accused 2 had questioned why they had been refused entry when they had credentials and were entitled to enter. Sub 24. He had calmed accused 2 down and told him to get into the vehicle so that they could enter the cemetery. Sub 25. He had sent the vehicle directly to the main gate because it was a VIP vehicle. If it was not, then he would have sent it to the left side. Sub 26. He agreed that both of the accused had believed that they were entitled to enter the cemetery for the burial ceremony. Under re-examination, confirmed that he had allowed the vehicle into the cemetery because he had seen 2 VIP gentlemen in it. So by pause to mention, in response to everything that's been quoted thus far, there are footnotes that refer to the transcript and the particular date, page, and line numbers in order to validate what's stated on behalf of the witnesses. There's then a subheading, Your Worship, further state witnesses. 45. Thereafter, the state released Sergeant Makobi as a state witness and made her available to the defense. 46. Subsequent to that, the state applied for another postponement to secure General Zulu as a state witness because she was yet again sick. Similarly, on 7 April 2022, she had sent a sick note to the state in which it was claimed that she had been examined on 5 April 2022 and was unfit to work from 6 to 8 April 2022. 47. Thereafter, the state applied for a postponement of the matter, which was opposed. 48. The state was then warned by the presiding magistrate that the provisions of Section 342 capital A would be applicable with regards to any further delays. The matter was then remanded to 6 May 2022. 49. On 6 May 2022, the state recorded that it had consulted with General Zulu the previous day and expected her to be in attendance, but had yet again received a sick note claiming that General Zulu had been examined on 5 May 2022 and booked off from 4 to 8 May 2022. In the circumstances, the state applied for a further postponement of this matter. 50. This application was opposed, and the presiding magistrate refused it. The state was then compelled to close its case and agreed times within which heads of argument would be filed concerning this application in terms of Section 174 of the Criminal Procedure Act. Subheading discussion. 51. Whilst the testimony of the state witnesses was improbable, riddled with contradictions and less than acceptable, a distinction must be drawn between the evidence concerning the chain of custody and the admissibility of the real exhibits on the one hand and the eyewitness testimony on the other hand. 52. Regarding the real evidence and chain of custody of evidence, the video footage was admitted and viewed in court by consent. There can be no doubt that Exhibit 4 was manipulated and does not contain all of the photographs that were created by and intended by Warrant Officer Smith to be in it. 53. In relation to the eyewitness testimony, and due regard being had to the case law cited above, as well as the evidence led by the state in this matter, it is respectfully submitted that there is no evidence that the accused committed the offence referred to in the charge, or any offence of which they may be convicted on the charge, so this court is entitled to discharge the accused and return a verdict of not guilty. 54. This is particularly so if regard is had to the material contradictions in the testimony of the complainant, Colonel Venter, as compared to his own written statements, and further to the testimony and statements of the other eyewitness, Staff Sergeant Mapisa. 55. Most significantly in this regard, Colonel Venter's version and his basis for refusing the accused to enter the cemetery in their vehicle changed from initially being that, sub 1, nobody other than the immediate family and the president were allowed to enter in vehicles, to sub 2, only accredited vehicles with permits could enter, To sub 3, the accused vehicle had not been part of the convoy. To sub 4, the accused vehicle was not accompanied by an escort. To sub 5, even if the accused vehicle had such a permit, he would not have allowed it in. To sub 6, he had radioed VOC to obtain permission for the accused vehicle to be allowed in. To sub 7, General Zulu had not permitted the accused vehicle to enter the cemetery. To sub 8, General Zulu had permitted the accused vehicle to enter the cemetery. To sub 9, only General Zulu could explain why she had allowed the accused vehicle to enter the cemetery. 56. In addition, the failure by General Zulu to testify cannot be ignored. It is common cause that after the confrontation between the complainant and the accused, she, in her capacity as the superior officer, granted the accused permission to enter the cemetery in their vehicle, and no action was taken against them for having done so. 57. In the circumstances, it is clear that they were entitled to enter the cemetery, and the complainant was not entitled to prevent them from doing so. 58. Additionally, and as detailed above, Staff Sergeant Mapisa had expressly stated, paragraph 2 of Exhibit L, quote, that the vehicles that were being escorted were directed straight to the VIP parking, including the Black Vito, which was transporting the accused. The word including is underlined for emphasis. Paragraph 59. Guard being had to Exhibit 1, the VIP parking was only accessible via the main gate that was manned by the complainant. It is thus clear that he was not entitled to deny access to the vehicle transporting the accused. 60. These submissions are further amplified and borne out by the official program, Exhibit A, which indicated that accused 1 was scheduled to deliver tribute to the late Winnie Madikizela-Mandela at the burial ceremony. 61. Over and above the official program, Exhibit A, regard must be had to the statement by Ambassador Zinzi Mandela, Exhibit E, the deceased daughter of the late Winnie Madikizela-Mandela, in which he states inter alia that, quote, I was shocked to learn recently that Mr. Julius Malema was on the verge of being criminally charged for being involved in a scuffle with Lieutenant-Colonel Venter of the South African Police Service at the gate of the 4A cemetery on the date of my mother's funeral. I was even more appalled on the day in question when I was told that some members of the South African security forces who were on official duty at my mother's funeral had attempted to prevent Mr. Lema from entering the cemetery to pay his last respects to my mother, who literally raised him and regarded him as her own biological child and son. This is a fact that is or should have been known to any person who regards themselves as South African. In any event, any security briefing preceding the funeral ought to have been identified as the most obvious members of the Mandela family, including our extended family. It was no coincidence that Mr. Malema was one of the key speakers at my mother's funeral. Despite some political resistance, the Mandela family had insisted that Mr. Malema be part of the program. Without him, the funeral would have been incomplete or carried out against the wishes of the person being buried. Again, any member of the security forces ought to have been briefed about or be in possession of the program. To prevent Mr. Malema from entering the cemetery would have created the most serious violation of the specific wishes of the Mandela family. To prevent a son from burying his own mother in the name of the law is an unthinkable act of provocation. There was in any event no justification for attempting to block Mr. Malema from entering the graveyard. Paragraph 62. According to the distinguished author C.R. Snyman in the textbook entitled Criminal Law 6th edition at pages 98 to 99, I quote, one must always first establish whether an act which accords with the definitional elements is not perhaps justified because the legal convictions of society deem the act committed in those particular circumstances in fact to be lawful. The act is then not unlawful. The grounds of justification must be seen as practical aids in the determination of unlawfulness. They merely represent the situations which are most often encountered in practice, which have therefore come to be known as easily recognizable grounds for the exclusion of unlawfulness. They do not cover the whole field of the subject of this discussion, namely the demarcation of lawful and unlawful conduct. The following is an imaginary example of a situation where X's act, which at first sight seems to break the law, is in fact not unlawful, despite the fact that it does not fall under one of the recognized grounds of justification, which will be discussed below. X is the owner of an attractive guest house next to a tarred road. The success of a business depends upon the traveling public being able to reach a property via the tarred road. Over the years, the provincial authorities responsible for keeping the road in good repair neglect their duties, with the result that the road becomes near impossible. X's complaints and asks authorities to repair the road, but the request falls on deaf ears. At last, she and people in her employ break the existing pieces of tar, remove them, and retar the impossible piece of road. As a result of her actions, she is charged with the crime of malicious injury to property, in that she had destroyed parts of the road belonging to the provincial authority. She can then successfully rely on a plea that her conduct was lawful, it accorded with the community's perception of justice or the legal convictions of the community. It caused more benefit to society than any conceivable harm and was therefore socially adequate. 63. In any event, the objective facts speak for themselves. The accused were permitted to enter in their vehicle without hindrance after the intervention by General Zulu, and in accordance with the established protocol of the day, their vehicle having been part of the convoy and bearing the requisite permit to do so. 64. Consequently, both accused should be discharged in terms of the provisions of Section 174 of the Criminal Procedure Act 51 of 1977. Then it's signed by myself in this form, Your Worship, dated 12th of May 2022. I beg leave to hand up the signed, corrected version, if I may, Your Worship.
You may do so. Thank you.
Thank you, Your Worship. I have no further ado, Your Worship.
Thank you. Court received then the heads of arguments, and it will be marked as Exhibit M.
As Your Worship.
Thank you, Ms. Hart.
In the Magistrate Court for the District of Johannesburg North, held at Randburg, in the matter between the State and Julius Malema, accused number 1, Mbuyiseni Ndlozi, accused number 2. State's heads of argument on application for a discharge in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Introduction. The two accused before this Honourable Court has been charged with assault as alleged in the charge sheet. The two accused pleaded not guilty and elected to disclose their defence in terms of Section 115 of the Criminal Procedure Act 51 of 1977. Sorry, Your Worship.
Yes.
The basis of the not guilty plea is that one of justification, both accused believed they were entitled to enter the cemetery for the burial ceremony, and that the obstruction of them was illegal and unjustified. In the circumstances, they lacked mens rea because they believed, at the very least, that they were entitled to enter the cemetery for the burial. I recall that there is a political agenda here. This is an assault common case. They both reached out to the complainant by process of Ubuntu that was rejected by AfriForum. So this turns out to be political, while that there is a political agenda between AfriForum and the EFF that is being played out in this court. Of the closure of the case for the state, both accused lodged an application for discharge in terms of the provision of Section 174 of Act 51 of 1977, the offence of assault definition. Assault consists of unlawfully and intentionally, A, applying force directly or indirectly to the person of another, or B, inspiring a belief in another person that force is immediately to be applied to him or her. Elements of the offence. Number 1, application of force or the inspiring of a belief that force is to be applied. Number 2, unlawfulness. Number 3, intention. The application before court in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Section 174 states that if at the close of the case for the prosecution at any trial the court is of the opinion that there are no evidence that the accused committed the offence referred to in the charge or any offence of which he may be convicted on the charge, it may return a verdict of not guilty. It is my humble submission that there are 3 words that are of utmost importance when considering this application, namely opinion, no evidence, may. In determining the interpretation of these words, it is of utmost importance to ascertain what the case authority highlighted as being interpretation thereof. In S versus Parker and others, 2004, 3 ALL, SA 501, SK at 504, I to J. The words no evidence have on numerous occasions been interpreted to mean no evidence upon which a reasonable man acting carefully may conclude. Circumstantial evidence consists of facts from which a fact in dispute may be inferred. It has been held that where the uncontradicted evidence of the state is circumstantial and more than one inference may be drawn, a discharge should be refused. It is a state submission that the evidence before court deals with direct evidence and thus the issue regarding circumstantial evidence is moot. In S v. Swartz 2001, 1 SACR 334 WLD 335E2F. Credibility in an application for discharge under Section 174 is one of the features to which the court can have regard, but it plays only a limited role. It is one of the factors to which the court have regard in the assessment of the quality of the evidence. The contextual scene, the evidence given in the case that conflicts with other evidence, which renders such evidence irreconcilable and unacceptable, all towards determining the quality of the evidence. It is the state submission that not only having direct evidence of the complainant Colonel Johannes Venter regarding the assault, this oral testimony is corroborated by the following evidence before court. 1. Video footage as real evidence. Number 2. The evidence of Mululeko Gilbert Mapisa. And number 3. The version placed on record by the accused's legal representative never placed the assault in dispute. I refer this honorable court to Bennett versus the Minister of Police, 1983 ALL SA 817C, 1993 SA 24C, where the court of course stated that lack of knowledge of wrongfulness is not a defense. Further on the aspect of wrongfulness, the court further stated that every infringement of the bodily integrity of another is prima facie unlawful. In Groenewald versus Groenewald, 1998 2 AL SA 335A, 1998 2 SA 1106, SCA, pages 1111 and 1112, an allegation of assault implies such an intention animus ignorandi. The plea explanation raises a defense of justification. Grounds of justification may be described as circumstances which occur typically or regularly in practice and which indicate conclusively that interference with a person's legally protected interest is reasonable and therefore lawful. In the article of G.P. Fletcher, Rethinking Criminal Law 2000, 759, see also L. Austin Philosophical Papers, 1970, 123 to 4, and also HLA, Hard Punishment and Responsibility, 1968, 13 to 4. George Fletcher explains by contrasting a justification with an excuse. The notion of justification and excuse have by now become familiar figures in our structural analysis of criminal liability. Claims of justification concede that the definition of the offence is satisfied, but challenges whether the act is wrongful. Claims of an excuse concede that the act is wrongful, but seek to avoid the attribution of the act of the actor. A justification speaks to the rightness of the act, an excuse to whether the act is accountable for a conceitedly wrongful act. The owners of
Well, we're coming out of that process, the state reading their response into record in that case against Julius Malema and Mbuyiseni Ndlozi. We'll take you back there when final summations are being made. But let's take you now live to the Pretoria High Court. The Senzo Meyiwa murder trial still continues.
For the beginner, I can be able to start. Your Lordship, I'm standing as I'm standing here because of the new discovery insofar as this matter is concerned, being that the continuation of this witness today, if my learned colleague has to continue, it will be a futile exercise. Why? It's because it has been discovered that my client, including even accused number 5, they made a first appearance in Boksburg on the 20. I was thinking I'm right to say the 26th of October 2020, but my client corrected me to say it was the 27th of October 2020. It was when they appeared in Boksburg court at 10 o'clock.
should add that, if anything, the contradictions points away from the conspiracy relied on. 9.8 F to G. In S versus Banana 2002 SAC R1 ZS. C, there will need to be an evidential basis for suggesting that the evidence of the witness may be unreliable. And if an evidential basis does not include mere suggestion by cross-examining counsel. In essence, a common sense approach should be applied regarding single witnesses. Where the evidence of a single witness is corroborated in any way which tends to indicate that the whole story was not concocted, the caution enjoined may be overcome and accepted, facilitated, but corroboration is not essential. Any other feature which increases the confidence of the court in the reliability of the single witness may also overcome the caution. In S versus Stevani, CC 15/2014, ZAW CHR 188 on 87/2014, to therefore summarize the legal position regarding application in terms of Section 174. An accused person is entitled to be discharged at the close of the case for the prosecution if there is a possibility of a conviction other than if he enters the witness box and incriminates himself. B, in deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may take into account the credibility of the state witnesses, even if only for a limited extent. C, where the evidence of the state witness implicating the accused is of such poor quality that it cannot safely rely upon, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, and revocation for discharge should be granted. In the matter of S versus Mpita and others, 1983 for SA 262C, Judge Williamson held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it, and that the credibility therefore plays a limited role at this stage of the proceedings. In S versus Manona 2001-1, SACR 4-60K, the accused applied for his discharge at the end of the state's case against him on a charge of murder. It emerged during cross-examination that the accused admitted having shot the deceased but alleged that it had been done in self-defense. There was no direct evidence against the accused, the only evidence being circumstantial evidence. The court held that an assault and the killing of a human being were actions which were prima facie unlawful. Once it became common cause that the accused had assaulted or killed the deceased or victim in self-defense, an evidential burden was placed on the accused to rebut a prima facie presumption of unlawfulness. In such cases, a discharge in terms of Section 174 of the Criminal Procedure Act 5197 could not be granted. The section gives the court a discretion in deciding whether to discharge an accused at the conclusion of the state's case. This discretion must be exercised judicially, and it is wrong to prescribe to a court how and when it should be exercised in favor of the accused. In S versus Manikwane 1996 to SACR 2640, also S versus Agliotti 2011 to SACR 437, GSJ at 257, where, however, more than one accused are charged with the same offence, the court may refuse to discharge one of them if it is in the interest of justice to do so. Agliotti at 257. When application for discharge at the end of the state's case is refused, there are no grounds for review where there is no proof of an irregularity in the conduct of the trial. Ibrahim versus Minister of Justice 2002 SACR 173W. If there is evidence on which a reasonable man may convict, the judge has no power to grant a discharge. R versus Tikle 1918-80-373. The charge and evidence before the court. The two accused have been charged with one count of assault. Facts not in dispute. The date, the time, the place, and identity of the parties are not in dispute. Colonel Venter, the complainant, is the one who stopped the vehicle wherein the two accused were passengers therein. There is no version from either accused that they did not assault the complainant in this regard. There was no dispute that Colonel Venter was going to get permission from the Venue Operations Center VOC to allow the accused vehicle to enter the premises. The charge and evidence before the court. The state submits respectfully that there is evidence that the accused before court assaulted the complainant. The complainant, Colonel Venter, testified how he was pushed more than once by the accused. Officer Mapisa testified how he saw both accused push the complainant. The state's witness, Officer Mapisa, testified that when he approached the scene of crime, he observed both accused assaulting the complainant. The evidence of Officer Mapisa corroborates the version and evidence of the complainant in this matter. The video footage corroborates the complainant's version as well as the evidence of the state witness that the complainant was assaulted by the accused, and Mr. Smith's evidence is also uncontested in regards to the fact that the video was not tampered with. It is submitted that the credibility of the witness for the state is not at stake at this stage, even if the complainant could possibly criticize for certain contradictions. The net result of that is not enough to say that his or her evidence as a whole was of such poor quality that no reasonable person could possibly accept it or it can never be believed. Despite the minor contradictions in the complainant's testimony, the video footage still corroborates the complainant's evidence. Further, the state witnesses corroborated the complainant's evidence before court. A reply to applicants' heads of arguments. The state will only concentrate on certain paragraphs of the applicant's heads of argument that warrant a response therein. ID paragraph 25.1. The state submits that throughout the evidence in this matter, it was never disputed that the two accused before court had a right to access the cemetery for the burial of the late Ms. Mandela. Reference is made to the paragraph 26.9 confirming the above submission. The point in issue was whether the vehicle in which both accused travelled had authorization to enter the cemetery. Specific reference is made to the testimony of the complainant who was busy contacting Venue Operations Center VOC to obtain the necessary permission from VOC to allow the unauthorized vehicle in which both accused travelling access into the cemetery. This submission is strengthened by the heads of argument by the applicant under paragraph 26.1.1. ID paragraph 25.2, we refer this honourable to the case law supra dealing with the issues of assault, which clearly deals with the aspects of intention. ID paragraph 25.3. The state concedes that no accused is required to supplement the state's case. However, the issue here is whether there is evidence before this court for the two accused to answer to. It is the submission of the state that there is a prima facie case before this honourable court that both accused need to answer to. 80 paragraph 26.5. It has always been the evidence before this court that the Mercedes-Benz Vito in which both accused travelled arrived a few minutes after the convoy arrived at the cemetery and was not part of the said convoy. This evidence has been corroborated by witness Mapisa. ID paragraph 26.12. The state agrees with this submission. However, the identity of the person who pushed him was later verified and confirmed via the video footage which was handed in as an exhibit. ID paragraph 27.4. The state submits while the incident was unfolding, the driver of the unauthorized Mercedes-Benz Vito vehicle proceeded to enter the cemetery with the unauthorized Mercedes-Benz Vito after both accused alighted from the unauthorized Mercedes-Benz Vito vehicle. Further, it should be noted that the last state witness, Mr. Mpiso, who was in full military attire, directed accused to return to the unauthorized Mercedes-Benz Vito vehicle, and there was no SABC members present during this entire incident that granted authorization to the driver of the unauthorized Mercedes-Benz Vito vehicle to enter the premises. At this junction, the unauthorized Mercedes-Benz vehicle already entered the cemetery. Reference made to video footage. ID paragraph 27.62. The evidence of the complainant was that this unauthorized Mercedes-Benz Vito vehicle was not part of the convoy, and in order to comply with the security protocols for the day in question, the complainant had to request authorization from VOC to allow access to the unauthorized Mercedes-Benz Vito access to the cemetery. However, before this could have been established, the accused alighted from the unauthorized Mercedes-Benz Vito and assaulted the complainant, and the whole incident of the assault transpired and was captured on video. Mr. Mpisa's evidence corroborates that the unauthorized Mercedes-Benz vehicle was not part of the convoy. AD paragraph 27.63. Notwithstanding the submission made by the defense, this issue should have raised with the investigating officer, which was never canvassed with him as part of his investigation. AD 33.33. The state submits that, as per complainant's testimony, he wanted to contact the VOC to request authorization from the VOC to allow the unauthorized Mercedes-Benz Vito vehicle to the cemetery, but was not given the opportunity to do so as he was assaulted while busy attempting to resolve the situation. AD paragraph 37.4. The state submits that even though photos of this original album was removed, this witness testified that the photos was images that was generated from the video footage that was supplied by him. Therefore, reference is made to paragraph 36.4 of this applicant's heads of argument. It is also noted on record through the testimony of the witness that the original docket disappeared. AD paragraph 53. The state submits that there is evidence before this honourable court that an assault took place on the complainant, and this is undisputed. Thus, the submission that there is no evidence that the accused committed the offence referred in the charge is unfounded and or misplaced. AD paragraph 61. We refer to Exhibit A and wish to submit that as per paragraph 2 of the program, accused 1 was a speaker at the Orlando Stadium on number 17 of the program. We further submit that the program for the burial of the late Ms. Mandela made provisions for only family members and the President of the Republic of South Africa. Insofar as Exhibit E is concerned, reference is made to the following. It was no coincidence that Mr. Malema was one of the key speakers at my mother's funeral. Despite some political resistance, the Mandela family had insisted that Mr. Malema be part of the program. Without him, the funeral would have been incomplete or carried out against the wishes of the person being buried. The above in no way indicate that the two accused before the court were part of the official ceremony at the gravesite. The above strengthens the testimony of the complainant insofar as the official instruction he received whom to allow into the cemetery. AD paragraph 62. The state submits that in order for the Honourable Court to determine the validity of the defence of justification, the Honourable Court also has to take into consideration the conduct of both accused in relation to their actions in avoiding this risk as a reasonable person under the circumstances would have done. The evidence of the complainant was that this unauthorized Mercedes-Benz Vito vehicle was not part of the convoy, and in order to comply with the security protocol for the day in question, the complainant had to request authorization from the VOC to allow access to the unauthorized Mercedes-Benz Vito access to the cemetery. The complainant was never given the opportunity to confirm and to verify authorization for the access of the Mercedes-Benz Vito. AD paragraph 63. At no stage did the state indicate that the Honourable Court that it did not intend calling General Zulu as a witness. The circumstances surrounding the availability of this witness was problematic. The defence alleged that she gave permission for the vehicle to enter the premises and no action was taken against them for having done so. It is the state's submission that reference to the aforementioned is speculation. Only as General Zulu did not testify in respect of this point. Reference is made to the transcripts on page 70 and 71 dated 28 of October 2020. This submission was made by the complainant as per his own understanding of what General Zulu meant. Discussion. It is the state submission based on the plea explanation tendered by the defence. This Honourable Court can only make a just determination whether justification is a valid defence in this matter. This will place the Honourable Court in a position to assess the evidence in totality and in order to determine whether the defence of justification should stand or fail. It is the state submission. This can only happen once both applicants on whom the onus rests to prove an excuse or justification come and testify before the Honourable Court that circumstances existed that justify their criminal behaviour with which they have been charged. Rules of admissibility of evidence. The admissibility of evidence is based on the principle that A. Facts relevant to the issue in the legal proceedings may be proved. Section 210 of the Criminal Procedure Act stipulates that no evidence as to any fact, matter or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point or fact in criminal proceedings. R versus Trupedo, 1920, AD 58 at 62. Also, S versus Kokul, 1965, 3 SA 461, N at 475. The Supreme Court of Appeal in Mdlongwa, 2010, 2 SA CR 419, SCA 427F to H has finally given a conclusive judgment on this issue where it held undeniably and unequivocally that video evidence is real evidence and that it need not be established that the original footage was used in order to have it introduced into evidence. The basic evidentiary rule is that all relevant evidence is admissible unless excluded either by the common law or by statute. See Ex parte Roche, 1998, ALL SA 319W, also R versus Trupedo, 1920, AD 5862, and R versus Katz, 1946, AD 71 and 78. When dealing with the chain of custody, it is important to note that the crucial piece of evidence in Exhibit 3, the long video, the evidence before the court is that Dion Kleinbill, who is the first person who had control of the camera room, he was self-trained and he was requested to copy the recording by James Broncos. The docket disappeared and a new docket had to be reconstructed. The most important evidence that this Honourable Court has to take into consideration is that the witness, Warrant Officer Smith, stated that this video was not tampered with. Other features that the court can take into consideration is that the video had a timestamp which was continuous without any break in for this Honourable Court not to accept the authenticity and reliability of the video footage. The witnesses are clearly identifiable in the video in the footage and were able to corroborate their testimony
Inspector?
with.
Sorry, Ms. Hart, for the interference. The court will just request if you have a cell phone on or any device which is making noise or capable of being transmitted, now would be the official time to switch it off. It should have been switched off and kept off whilst the court is in session. So the next phone or device that will make a noise, Inspector, please remove such persons from the proceedings. It is disturbing the proceedings. Sorry for the interruption, Ms. Hart. You may proceed.
This is the court. I'll just start from again with the last sentence.
Yes, you may.
The witnesses are clearly identifiable in the footage and were able to corroborate their testimony with the viva voce evidence in this regard. Regarding the real evidence and chain of custody of evidence, the video footage was submitted and viewed in court by consent. Transcripts dated 28/10 of 2020, pages 82 to 84. Real evidence. Real evidence is an object which upon proper identification becomes of itself evidence, such as a knife, photograph, voice recording, letter, or even the appearance of a witness in the witness box. Real evidence consists of things which are examined by the court as means of proof upon proper identification, and it becomes of itself evidence. Upon proper identification, real evidence must only be relevant for it to be admitted. In S versus M 2002 2 SACR 411 SCA at paragraph 31. If so far as the argument regarding Exhibit 4, it is the state's submission that this witness did not attempt to justify the shortage in the photographs. He conceded that certain photos were not part of the album. However, he also testified that these photos were developed from the video footage supplied to him. This real evidence was handed in as Exhibit 3, and the authenticity and reliability is not in dispute. The state would also wish to refer to the testimony of Dean Cleanville, who testified that the original docket disappeared and the blame for missing photos cannot be levied to Warrant Officer Smith. The state submits that in order for the Honourable Court to determine the validity of the defence of justification, the Honourable Court also has to take into consideration the conduct of both accused in relation to their actions in avoiding this risk as a reasonable person under the circumstances would have done. The evidence of the complainant was that this unauthorized Mercedes-Benz Vito vehicle was not part of the convoy. In order to comply with the security protocol for the day in question, the complainant had to request authorization from VOC to allow access to the unauthorized Mercedes-Benz Vito access to the cemetery. The complainant was never given the opportunity to confirm and or verify authorization for the access of the Mercedes-Benz Vito. It is the state submission that in all probability the defense would have succeeded if the two accused before court had been charged with trespassing but not assaulting the complainant. The state further submits that it is common cause that the complainant at no stage interacted with the two accused before court regarding the issue of access. Further, there were never any stage harm directed towards the two accused before court that could have justified the unprovoked assault of the complainant. Thus, the issue of justification as defense should fail. In S. Vincent Chake, Mlambo, 1987, 1 PHH 19A, the court of quote stated the following. At the outset, it should be borne in mind that when, in the course of investigation of a crime, a statement is taken from a witness by the police, there is an imminent risk of inaccurate reproduction in the statement as recorded by the police, of which the witness has in fact told the police. The extent of the risk of distortion obviously depends upon the circumstances in any given case. With reference to the credibility of the testimony of Mr. Mapisa, the state submits that Mr. Mapisa gave an explanation regarding the manner in which his statement was taken down, and reference is made to the transcripts on page 40 and 43, 40, 43 and 46 dated 7th day of April 2022. Similarly, the same applies to the complainant therein. Sorry about it. It is absurd to expect a witness to furnish precisely the same account in evidence as given in his or her statement, Brainers 1998 to SACR 432 SE. In Malafidiso versus the State 2003 1 SACR 583 SCA 593J to 594A2G, the court of quote stated the following. Discrepancy in statement caused by one sentence only could be interpreted in one of two ways, must be read in the context of the whole statement. Held that the court must handle discrepancies between different versions of the same witnesses with circumspection. First, the court must ascertain what the witness meant to say in order to determine whether there was a discrepancy and the extent of the discrepancy, Your Worship. The court must take into account the following: the fact that a statement to the police was not subject to cross-examination, languages, cultural difference between the witnesses and the person who took the statement, and the fact that the police did not require any explanation of a statement. Secondly, not every error by or discrepancy in the statement affects the witness's credibility. Thirdly, the different version must be evaluated holistically. This evaluation includes the circumstances in which the versions were given, reasons for the discrepancies, the effect of the discrepancies on the witness's credibility, and whether the witnesses had sufficient opportunity to explain the discrepancies. Lastly, the witnesses statement to the police must be weighed up against the revoke evidence. Further, in support of this submission for the refusal of the Section 174 application, I refer the matter to S. Mjoli in 1981, 3 SA 1233A. It was held that even though that an admission by an accused during explanation of plea is not evidence, it is still probative value. Himsra CJ in S versus Mogatla 1977, 9 BSC 27985E remarked as follow in relation to the admission not recorded in terms of Section 220 of the Act. Like in the case of an extrajudicial statement, the accused may be cross-examined on it. Serious conflicts between his evidence under oath and his explanation of plea can destroy his credibility, provided the conflicts have been properly put to him. The view that everything in the explanation of plea which is not an admission in terms of Section 220 must be totally ignored cannot be supported. It is part of the evidential material like any other statement made by the accused which may be proved against him in evidence, whether inculpatory or exculpatory or neutral. The value of the prosecution depends upon the circumstances. This is in accordance with the general law of evidence, and there is nothing in the Act which takes the explanation of plea out of this general clause. The aforementioned views was further confirmed in the matter between the Director of Public Prosecution versus Ben Maramba and others. In S versus Henry 1999, 1 SACR 13, SCA, Judge Scott held at 20 CI. It has been repeatedly emphasized in the past that defenses such as non-pathological autism required to be carefully scrutinized by the very nature of things. The only person who can give direct evidence as to the level of consciousness of an accused person at the time of the commission of the alleged criminal act is the accused himself. Its predicate to the effect of his act was involuntary and unconsciously committed must therefore be weighed up and considered in the light of all the circumstances, and particularly against the alleged criminal conduct viewed objectively. Ultimately, it is for the court to decide the true nature of the alleged criminal conduct, which it will do not only on the basis of the expert evidence, but in light of all the facts and circumstances in the case. It is further submitted, as stated above, that sufficient evidence have been presented and placed before this honourable court upon which a reasonable man court may convict. The state therefore submits that the application of Section 174 of the Criminal Procedure Act should be dismissed, and the accused's version of justification needs to be tested whether it is a valid defence acceptable to the court or not. Dated at Randburg on the 20th day of May 2022, signed by myself, Your Worship. May I hand this copy to the court, which I signed,
Yes,
Your
you may.
Worship?
Court received, and we'll mark it as Exhibit N. Thank you, Mr. Ouders. Is there any further comment you want to make? None.
Your Worship, there just seems to be one error with the exhibits. We have an Exhibit L already, Your Worship. It was the witness statement of Sergeant Muller, Becky Gilbert Mapisa, dated 2nd of December 2019. So in my head to become M, Your Worship, and my learned friend's head to become N. I don't think your list was updated, Your Worship.
Updated the list which I have would indicate the last one was L.
Yes, Your Worship. L,
Which
mine
is-
is M and my learned friend's is N.
M.
As Your Worship is.
So, what is the last exhibit? Can I just get clarity? Your last?
My heads of argument, Your Worship, would be M for Max. My learned friend's heads of argument would be N for Nelly.
Because the last one was L.
Yes.
So can I get the last exhibit, which was the statement of Mr. Mapisa?
Yes.
Is that marked as L or M?
L, Your Worship.
L.
Yes, Your Worship.
Thank you. So then it is correct that your heads of arguments is to be marked as Exhibit M,
Yes,
and then the state will be Exhibit N.
as your please.
Indeed, so your should confirm.
I believe both parties do not have any further submissions with regards to the application.
None, your worship.
I am going to ask the two accused to remain seated for purposes of the judgment itself. I see no reason why they should stand for the mere fact of the judgment in this regard, so you may remain seated. I've also just wants to place on the record, both parties, the court have received their heads of arguments timeously, and Mr. Houders as well as Ms. Hart have read their heads of arguments into the record. With regards to the heads of arguments received by Mr. Houders in this regard, which is marked as Exhibit M, it was read into the record from pages 1 to 10, as well as basically the whole heads of arguments will also refer to footnotes in this regard. The footnotes was not read into the record from page 1 to page 10. It is mostly also referring the court to numerous case laws and what has been indicated in that case law itself. From page 10 onwards, it is basically the footnotes make reference to extent of the transcripts itself. So that forms also part of the transcript. It also forms part of the heads of arguments, which was duly taken into consideration by the court. The said exhibits is then marked, and it is now signed by both parties, and the court thank both parties for handing the heads of arguments. The heads of arguments of Mr. Houders, Exhibit M, consist mostly in the application, and the crust of this application rests on the extent of credibility of the said witnesses who testified before court, and then also with regards to unlawfulness and the intent. The state also then relied specifically on direct evidence to indicate to the court that the court should not grant this application because there is direct evidence with regards to the assault which is before court. And the state also further deals in the heads of arguments with real evidence, and the record is stated as well as the heads of argument. It's common cause between state and the defense that the court have received Exhibit 3, which is the video footage by consent of the parties, and have ruled that it is admissible before the court. So no further aspect with regards to referral of case law concerning such is to be dealt with. Also with regards to the discrepancies of the state witnesses as well as the statements which is before court, which the court will then also deal with in that regard. With regards to non-pathological automatism, the court will also not comment on such because of the direct evidence which is before court, which will be assessed in this regard. Therefore, the two accused before court has been charged with an offence of assault. It has been alleged that upon the 14th day of April 2028, and at or near Fourways Memorial Park in the district of Johannesburg North, the accused did unlawfully and intentionally assault Johannes Jacobus Venter by pushing him. The state further alleged that the two accused at all material times acted in the furtherance of common purpose. The two accused also pleaded not guilty and elected to disclose their defense in terms of Section 115 of Act 51 of 1977, the Criminal Procedure Act. Plea explanation. The grounds of justification, both accused believed that they were entitled to enter the cemetery for a burial ceremony, that the obstruction of them was illegal and unjustified. Subparagraph B, in the circumstance, they lack mens rea because they believe at the very least that they were entitled to enter the cemetery for a burial service. Subparagraph C to paragraph 2. Further, that there is a political agenda here at play. This is an assault common case. They both reach out to the complainant by way of Ubuntu that was rejected by AgriForum. So this turned out to be that there is a political agenda between AgriForum and the EFF, which is being played out here in court. Paragraph 3. Therefore, in terms of Section 174 of Act 51 of 1977, accused may be discharged at close of the case for prosecution if at the close of the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offence of assault referred to in the charge sheet or any offence which they may be convicted on the said charge. It may return a verdict of not guilty. Paragraph 4, it is common cause that the parties, as per the heads of arguments in the cited cases, the cited case law concerning the development and the history of an application in terms of Section 174 of Act 51 of 1977, the Criminal Procedure Act, subparagraph A, referred to by the defense in paragraph 2 to paragraph 25 of the defense's heads of arguments, to paragraph 10 and others of the state's heads of arguments. However, when the court used the term others, it is because it is difficult to correctly identify the exact paragraphs of the state's heads of arguments, since the numbering is incorrectly or vaguely used in this regard. The only real reference to the state's heads of arguments will be the pages, but it has become too complicated to refer. The following principles, which is being dealt with in the heads of arguments of both parties, is the following. Whether there is a prima facie case which has been proven by the state, no evidence, credibility, not to incriminate yourself. Paragraph 6, I am in agreement with all the reference and cited cases and the above mentioned principles, and that the onus rests on the state to prove the allegation of assault on a prima facie basis and not beyond a reasonable doubt at this stage. Paragraph 7, the words no evidence have on numerous occasions been interpreted to mean no evidence upon which a reasonable man acting carefully may convict. Paragraph 8, I agree that the court may also act mero motu and should do so where the accused is unrepresented. The case of Zimmerich, 1989, Volume 3, SA 184 in brackets C, as well as the case of America, 1999, Volume 2, SACR 480 in brackets C, whereas the decision to refuse or grant a discharge is a matter solely rested within the discretion of the presiding officer, and such discretion must be exercised judicially. Paragraph 9, it has been held that credibility was not a matter that should be taken into account when considering a discharge, as it was a matter to be considered at the appropriate time. The second case of Dladla, 1961, Volume 3, SA 921 in brackets D, as well as the case of National Board of Executors, LTD, 1971, Volume 3, SA 817 in brackets D. However, credibility was considered a relevant factor in the case of Nanda Gopal Naidu, 1966, Volume 1, PH H104 in brackets W, as well as the case of Norki, 1961, Volume 2, PH 166 in brackets O. Also in the case of Power, 1964, Volume 3, SA 800 in brackets 0. As well as in the case of S versus Mpeta, 1983, Volume 4, SA 262C, at page 265, paragraphs D to G. As well as in the case of S versus Swart, 2002, Volume 1, SACR 334, in brackets WLD, at page 335, paragraphs E to F. However, in the case of Mpeta, it was indicated after analyzing the various decisions, Judge Williamson stated, however, it must be remembered that it is only a very limited role that can be played by credibility. At this stage of the proceedings, if a witness gives evidence which is relevant to the charge being considered by the court, then that evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. This would really only be in the most exceptional cases where the credibility of a witness is so utterly destroyed that no part of his material evidence can possibly be believed. Before credibility play a role at all, it is a very high degree of untrustworthiness that has to be shown. It must be overlooked that the triers of fact are entitled, while rejecting one portion of the sworn testimony of a witness, to accept another portion. Case of R versus Kumalo, 1916 AD 480 at page 484. Any lesser test than the very high one, which in my judgment is demanded, would run counter to both principles and requirements of Section 174. Thus, credibility play only a very limited role, and evidence could be ignored only if it was of such poor quality that no reasonable person could possibly accept it. In the case of S versus Swartz, 2002, Volume 1, SACR 334, in brackets W. It was stated that when assessing the quality of evidence, this was not done in a vacuum. Credibility of a witness in an application for discharge was one of the features to which a court could have regard. In causa, the court found the quality of the state witness to be of such poor quality that no reasonable man acting carefully could convict thereon. The case of Zuma, 2006, Volume 2, SACR 191, in brackets W. When dealing with an application for discharge of an accused at a closure for the state's case, the judge remarked as follows. The complainant's evidence, as stated in the short judgment, was not so broken down that it could not be, the court will just repeat the sentence. The complainant's evidence, as stated in the short judgment, was not so broken down that it could be disregarded. In the case of Lubaksa, 2001, Volume 2, SACR 703, in brackets CHA. The judge indicated as follows regarding Section 174. Section 174 of the Act repeats all material respects the terms of its predecessor in the 1917 and 1955 Criminal Code. It permits a trial court to return a verdict of not guilty at the close of the case for the prosecution if the court is of the opinion that there is no evidence, meaning evidence upon which reasonable person might convict. The case of S versus Kanyapa, 1979, Volume 1, SA 824, in brackets A, at page 838, paragraph F to G, that the accused committed the offense with which he is charged, or an offense which is a competent verdict on that charge, if in the opinion of the trial court there is evidence upon which an accused might reasonably be convicted, its duty is straightforward. The accused may not be discharged and the trial must continue to its end. It is when the trial court is of the opinion that there is no evidence upon which the accused might reasonably be convicted that the difficulty arrives. The section purports then to give the trial court a discretion. It may return a verdict of not guilty and discharge the accused there and then, or it may refuse to discharge the accused, thereby placing him on his defense. Now, the case of S versus Duwani has been referred to by state as well as the defense. The citation is also on the said papers of both parties as well. It summarized the legal position regarding the application in terms of Section 174. An accused person is entitled to discharge at the close of the case of the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminate himself. in deciding whether the accused person is entitled to be discharged at the close of the state's case, the court may take into account the credibility of the state witnesses, even if only to a limited extent. Whether evidence of the state witness implicate the accused is of such poor quality that it cannot safely rely upon, and there is accordingly no credible evidence on record upon which the court, acting carefully, may convict, the application for discharge should be granted. So the court should, in our current constitutional dispensation, always prevent that an accused is placed on his defense in the event that there is no evidence upon which a reasonable court acting judicially may convict on. I therefore have no doubt that the accused person, whether or not he is represented, is entitled to be discharged at the close of the case for the prosecution if there is no possibility of convicting other than if he enters the witness box and incriminate himself. The failure to discharge an accused in those circumstances, if necessary, mero moto, is in my view a breach of the rights that are guaranteed in the Constitution and will ordinarily vitiate a conviction based exclusively upon self-incriminatory evidence. Paragraph 12. So in light of the above, it is also important to look at the charge which the accused has pleaded to. Subparagraph A, the author Milton at 406 defines assault as follows. Assault consists unlawfully and intentionally applying force to the person of another or inspiring a belief that force is immediately to be applied to him. Subparagraph B, assault to define by the author Snyman at page 430 as follows. Assault consists in unlawful and intentionally applying force directly or indirectly to the person of another, inspiring a belief in another person that force is immediately to be applied to him or her. Paragraph 13, the elements would then mostly consist out of acts, unlawfulness, and intention. Subparagraph A, the act itself. The element manifests itself in one of two ways, namely through the application of violence and through threats of violence. Subparagraph B, unlawfulness. The legal conviction of the community requires that the physical integrity of a person should be protected. This, however, does not mean that every impairment of the said physical integrity will constitute unlawfulness. The impairment of the physical integrity of a person will be unlawful when, according to the objective reasonableness criterion, it is unreasonable. Then subparagraph C, intention. The perpetrator must have the intention to apply force or violence to another person. In this regard, we may see the case of Rebo 2007, Volume 2, SACR 292, in brackets ECD. In this regard, or to threaten him as such a way that a belief or fear is inspiring in the mind of the latter with the above mentioned qualification. Paragraph 14. Now, I am mindful, as per the defense heads of arguments, paragraph 26 to paragraph 44, which deals with the summary of the state's evidence and the reference to credibility of the witness, specifically the complainant. Likewise, the state's heads of arguments dealing with the same principles, but as I've had earlier indicated, direct reference would be confusing as per the numbering of the state's heads of arguments. But I assure the state that I have applied my mind to all the submissions surrounding these issues. Paragraph 15. Before I reach conclusion, I like to refer to the case of S versus Manakwane, 1996, Volume 2, SACR 264, in brackets EC at page 267, paragraph J, where Judge Nugent stated that it is wrong to attempt to be prescriptive as to when exactly and under what circumstances this discretion should be exercised in favor of the accused. Whether the discretion will be exercised will depend on the facts of each particular case. The presumption and combination of the circumstances which can arise in practice are virtually infinite, as are their nuances, and it could be foolish to try to compile a comprehensive list of factors, let alone list them in order of importance. For the same reason, it is unwise to place too much stress on what Judge A had occasion to say in case A about the factors or the measures which had to enjoy priority in that case. Decision to allow or refuse a discharge is a judgment tried to the facts whereby the entire spectrum of circumstances plays a role. It is therefore respectfully submitted that even cases at the extreme of the spectrum, such as Moore, Kritzinger, Harold, Hector, Chopin, and many more, each assessed in the context of its own particular set of facts and are not totally irreconcilable. Judicial remarks on factual issues, irrespective of the universal nature of the language used to express them, are not principle. Even less do they constitute binding precedents. At best, they are useful analogous indicators of what was done in comparable cases. Paragraph 16. Now, therefore, the court will specifically look at whether the evidence of the state has the possibility of a conviction on the arranged charge. The state has called 6 witnesses, namely Colonel Johannes Venter, Dion Klingbeil, Colonel James Bronkhorst, Colonel Charles Sianego, Warrant Officer Jacobus Nicholas Vosloo Smith, and Staff Sergeant Gilbert Mapisa. In addition to the oral evidence, the court has received the following documentary as well as real evidence. Under paragraph 17A, sub A, exhibit 1 to 2 is photograph parking spaces. B, exhibit 3, video evidence. Exhibit 4, under subparagraph C, photo album compiled by Mr. Smith. Subparagraph D, exhibit A, funeral program of the late Winnie Mandela. Under paragraph E, exhibit B to L is witness statements. Therefore, the court has reached the following conclusion under paragraph 18. Now it goes without overemphasizing the fact that the state's case has discrepancies specifically with regard or reference to the complainant's, Mr. Venter's, evidence and Staff Sergeant Mapisa's evidence, which is relevant to the charge of assault. The other witness evidence don't relate to the assault directly, but indirectly only towards the real evidence. These witnesses' evidence is to be viewed as formal and relate to the video mostly and investigation and what investigations was done. At this stage, I found that the evidence not to be relevant for the application before court due to the video being allowed by consent and is admissible as evidence before the court. Therefore, when I look at the direct evidence in regard to the assault, I agree that Mr. Venter's evidence, when challenged, whether the accused may enter the cemetery with their vehicle went from, as referred to by the defense, nobody other than the family and the president, as well as the deputy president, were allowed to enter in vehicles. Only accredited vehicles with permits could enter. The accused vehicle had not been part of the convoy. The accused vehicle had no escort. Even if the vehicle had a permit, he would not allow it to enter. He contacted the venue operations center to get permission to allow the vehicle in. General Zulu didn't give permission. On the question of General Zulu, I was addressed by both parties also with regards to General Zulu. General Zulu never gave evidence before the court, and the court cannot place any weight with regards to what was said. So anything referred to General Zulu is not before the court and cannot be taken into account. The evidence by the state witnesses of whether the accused was allowed then to go into the cemetery with the vehicle is not clear, nor convincing in any manner. One cannot take the oral evidence in isolation of the written statements of the witnesses. It does not speak with one voice. It creates different scenarios and has an effect on credibility to what the court must accept as the correct version. Even in light of these discrepancies, the court must specifically look at the following as well. Facta probanda, facts in issue are those facts that the party must prove to succeed in a case. The facts in issue are, generally speaking, determined by the substantive law, as for example, the elements of an offence determined by the substantial criminal law. Under subparagraph B, facta probantia, facts relevant to the facts in issue are those facts that tend to prove or disprove, rebut the facts in issue, and from which inferences may be drawn about the facts in issue. Facts relevant to the facts in issue are, generally speaking, determined by the rules of procedure, formal law, such as, for example, criminal procedure, and in particular, the law of evidence. Under paragraph C, examples of facts in issue and facts relevant to the facts in issue on a charge of assault. The facts in issue will be application of force, unlawfulness, intention. Examples of facts relevant to the facts in issue will be evidence that the accused did not act in private defense or that there was an imminent danger of being attacked by complainant, as well as justification. Paragraph 20. Now it is clear from Exhibit 3 that the accused vehicle is the last one to arrive and being stopped by Colonel Venter. It's further clear on the video that both accused has been seen pushing Colonel Venter to the extent that he nearly fell against the guard's house. This basically happened in mere seconds, even though that their vehicle was the last vehicle after the two BMW SUVs X5s with blue lights to support Colonel Venter's version. It still remains unclear of what should be the first and last vehicle to enter the cemetery. On the video, there is a marked vehicle, vehicles with blue lights on, and also unmarked cars, as indicated by the witness, that other cars or other vehicles was rented and would therefore not be marked at all. No list given to him of all vehicles that should enter. On the version of Colonel Venter of how the convoy was compiled, kept on changing as mentioned above. Therefore, it is highly debatable on how these operations was deployed for the safety of the President, ministers, deputy president, as well as heads and ex-heads of states, specifically if you were stopped and have no right to enter, but later also have entered. This then, in return, will defeat the whole purpose of regulating entry with safety in mind. Also take into account that plus minus 4 years have passed, and until present, it is still not equivocally clear that the accused had the right to enter or not with his vehicle. The issue was also attempted to be rectified, which is then reference to multiple statements being done by Colonel Venter without success. Further, these discrepancies go to the crust of entry into the cemetery and not directly to the definitional elements of the offence of assault. I will therefore refrain from making a credibility finding at this stage as the quoted authorities by the defense and the state is clear that credibility only plays a limited role at this stage. Unless his credibility as a witness was so utterly destroyed that no part of his material evidence can possibly be believed. The material part of his evidence, with reference to Exhibit 3, stand, and it is prima facie proof of assault. When dealing with the accuser's right to enter, one should also take into account the following: the definitional elements of the offence of assault. Firstly, dealing with conduct, it is common cause between the state and the defense that assault may be committed by the slightest contact of the body of the complainant, as per illustration on Exhibit 3. For an example, the courts have held that X commits assault merely by walking to Y and knock Y's head from his head. In this regard, we may refer to the cases of Herbert, 10 CRT 516. In Herbert, the accused removed the complainant's head from his head, and in Goosen and Lamini, the accused took a woman by the arm and said, "Hello, my sweetheart." Also in R versus Van Vieren, 1961, volume 3, SA 305 in brackets E. So the slightest touch of a human, of the body of another person with the intent could be considered as an assault. This leads us to the aspect of the dispute between the state and the defense, whether an accused has acted in a form of justification which will exclude unlawfulness or unlawfully and intentionally. The court will just repeat paragraph 22. This leads us to the aspect of the dispute between the state and the defense, whether an accused has acted in a form of justification which will exclude unlawful and intention to commit the offense of assault. I'm aware that a person acts in private defense in protection of his life or bodily integrity, but in principle there is no reason not to accept that a person may act in private defense or protect other legal interests. The court have accordingly recognized private defense in protection of property, dignity, freedom of movement, also prevention from unlawful arrest, and so forth. With reference to the cases of S versus Chingaza, in brackets, this is the actual case number, case stroke S 15/2011, which is a Northern Cape High Court, which was decided in Kimberley. Also the case of S versus Mona, volume 1, SACR 426 in brackets TK. In this case, the court dealt with the application of discharge of an accused in terms of Section 174 of the Criminal Procedure Act. In my view, the principles enunciated in this decision is opposite. Appeal Judge Krieger, who was confronted with almost similar situation, made the following remarks. Subparagraph A, an assault and the killing of a human being is an action which is prima facie unlawful. Once it becomes common cause that an accused has assaulted or killed the deceased or victim in self-defense, an evidential burden is placed on the accused to rebut the prima facie presumption of unlawfulness. In such case, a discharge under Section 174 cannot be granted. Therefore, I found that there is common cause between the state and the defense in terms of Exhibit 3. It is admitted by consent, and the court ruled that it is also admissible as evidence before the court. Reference also with transcript 2 of 28 October 2020, pages 82 and 84. Real evidence consists of things which are examined by the court as means of proof upon proper identification, and it becomes of itself evidence, as what was said in the case of S versus Matembu, 2008, volume 2, SACR 411 in brackets SCA. at paragraph 31. Real evidence usually bears the hallmark of objective reality, unlike narrative testimony. That depends on the say-so of a witness. What is then seen on a video is clearly or prima facie proof of an assault on the complainant. Mr. Venter's evidence is also clear that he maintained that he was assaulted by the actions of both accused. The justification of the assault, which is in dispute, must be tested. Furthermore, ignorance or mistake of law, every man must be taken to the cognizant of the law. Otherwise, there is no knowing of the extent to which the excuse of ignorance might be carried. It would be argued in almost every case. Paragraph 24. It stands to reason that the application, therefore, in terms of section 174 of both accused, is therefore then dismissed.
The accused already to testify.
Beg your pardon?
The accused already to testify.
Are ready to testify. I believe we did not have tea, we have proceeded into tea. I do not have an objection to proceed immediately, or do we break for 15 minutes and we'll be back at 4:02. You may stand. Court will adjourn for 15 minutes. We will resume with the matter at 4:02. Court adjourn.
All right.
Holders, are you going to use the video footage of the Are you going to use the video footage? It's not Can I cross in front of you? Whose mic is this?
The blue. Blue? You check over me across, yes? You check over me across. Across over Pilar.
Who can I cross with? I just want to get this left.
Yeah. Down. Yeah, you're on a punch. Sharp. Yeah, put a separate. From blue. Blue. Hey, I think I'm back to the because it's okay, sharp, sharp. Can you let the window pull on it? So maybe. There's a grand race of Habi. I know my sacrifice. I want to play my guy. Mountain. He's with me like he's ready. My friends are right. So what's the line? I can tell you number. Awungitholi angithi 5.6. Asante. Sobamba situ. Sobamba situ. Yeah. That's moving, but I don't know where it is.
Because I saw the thing about me giving consent, how can I consent to that right now? Thank you. If you can't see, you can capture on my side.
No, hold on. Yeah, there's. Let's get out of here. Return. Right, let's get out of here. Right, USB. No, let's get out of here too. Get out of here. And browse. USB. There you are. Which one is this? The big one. The one for that one. Okay. Make it all screen. Make it all screen. There, sir. Okay. Stop it. If you want to, I can move it for you then. Okay. You know, to make the life easy, you can move it here. There's no. Hold on. Yeah, it's running and I want to stop it. Yes, sir.
Not to stop this. It's just running.
Yeah.
Okay, how about this? How about this for asking, eh? Yeah.
Sisi, umi de marota buya ikurati.
Correct. Lava tlhela original office. Anda va yena.
Yeah, if batam for me and then that's it. Thank you, Mama. What time are you starting?
Yeah, I'm ready.
Oh,
There's a new start. Put it to.
I need to send people for this. I'm coming just now. Yeah.
Maybe it's like a big packet of chips is enough.
Big packets of chips.
Like chili, Simba chili chips, whatever, yeah. Big packet, we know the chili.
Big ones, ne?
Yeah, two workers.
Thank you. He doesn't want to.
just want to make sure everything is set up.
Okay, there we are.
Call me then, I need to go quickly bathroom.
No, okay.
Okay, you ready to start?
Just let's see quickly what from the start.
Okay, all you got to do is just look at
Okay.
you speak on there.
Oh, okay.
Yeah, I went out there. I want to deliver. Which is what number is?
Oh, hey, just.
Yeah, have you got others?
Just play with
Pause. You just play, reverse. There you are. Then we start from the beginning, right? You just play. I'll keep on coming in. If there's a problem, I'll sit in. Okay? If there's a problem, I'll come and sit in.
But then we have to know.
No, I'm just here. I'll pop in now. Let's
Where do we
Play
press
with
play?
me first, let him play first.
The bottom one.
Alright?
This one says play.
And remember when you hit slow motion, you're pressing it. Okay? Good.
Keep the battery in.
Remember, I don't compromise going to mosque. You know that. So, but if there's a problem, call me, I'll come help you guys. Alright?
Okay.
Okay?
Oh, you're back?
I'm waiting for you guys.
Go, he wants to go to the bathroom. Go. Go, Flippin.
No, I'll take longer.
So what now? Oh, I'll send it
At 12. Okay, sure. I remember.
No, it on and off. It only machine that on touch it. Well, it's something with his
Yeah, she's coming. Are you guys fine? Okay, I'm just in my office. If you need me, just send one message. I'll keep my phone right next to me.
You must just be the operator. Done. Magistrate in Court 6 is not done with this book, so what are we going to
Okay, let them finish. You can ask.
do? She can't finish now.
Is there long? Let them. No, you're still going to be busy, so by the time I finish. Only when he's done, then he's going to take the charge.
It's fine. If he's going to take the charge with him, I'll get the book when they are done that side. Okay.
As soon as you come back, you can start. Okay.
But you can organize the lunch.
I'm sorry.
Oh, I can take this one. I'll take this one.
Did you get the letter yesterday?
Which one again?
The robbery. Yeah. But it doesn't want to say.
Remember to send information on that.
Yes, I didn't know about it. I didn't place it. So I didn't place it. I didn't place it. So Mrs. Susana just asked me to quickly help and then I just typed out what he said quickly.
No, I received it. He sent me via WhatsApp and he says he sent me an email as well. So I'll check it afterwards, no problem. But did you give further instructions?
Mr.
give further instruction for investigation. So, but it's now what I didn't write for what was still happened. I just wrote for now. So further with ballistics and they have to confirm exactly for the uniform and all that stuff. And it's on.
Also, you placed it?
Yes, it's placed.
Oh.
It's placed. It's placed. Yes.
I thought you were saying it.
No, I didn't read it, but it's placed. So, what I said I did, what I really didn't
And the
place
next
it.
court date is?
The 8th of June.
All right.
May be seated. Just one moment, Mr. Otis. In the interim, we may be. Thank you. It's case number 3/4067/2019. The appearances at the resumption is as before. Thank you, Mr. Otis.
Thank you, Bishop. I call accused number 1, Mr. Malema, to testify.
Mr. Ndlozi, may be seated. Thank you, sir. Can you indicate to the court? Thank you, sir. Can you indicate to the court your full names and surname?
Julius Malema.
Mr. Malema, do you have any objection taking the prescribed oath?
No.
Do you consider the prescribed oath to be binding on your conscience?
Yes.
Raise right hand and repeat after me. I swear that the evidence that you are about to give will be the whole truth, nothing else except the truth, so help me God.
So help me God.
Thank you. Mr. Otis, your witness.
Can I please take off my...
Yes, you may do so. I'm not sure. Are you comfortable standing?
I'll indicate when I get tired.
It is in order, Mr. Malema.
Thank you.
Mr. Otis, you may proceed.
Thank you, Bishop. Mr. Malema, you are an accused arising out of an incident that took place on the 14th of April 2018. Can you please, going slowly, watching His Worship's pen, take us through your movements on the day of the 14th of April 2018?
Perhaps I will start a bit before that day when Mama passed away. We went to visit her house, and when we arrived there, we sent our condolences to the family, and the family said I was taken outside by both the late Zinzi and the Ambassador Zenani, the two daughters of Mama Winnie, that they would like me to give a speech on the day of her burial, and that they don't want me to speak on the memorial, I must speak on the actual day, that both the state and the ANC are refusing that I speak, that they do not want me to speak there, and they say it's a state funeral.
Can you just repeat? You say about the state?
Both the state and the ANC do not want me to speak there because it's a state funeral, and that in the state funeral ordinarily it will be president, a family and ministers who speak. And they told me that they've made it very clear to the ANC and to the state that he is going to speak, and if you insist that he should not speak, we are going to decline the state funeral, and then we'll bury her on our own because we must bury her according to a wish. I do not get surprised with what is happening today, because it occurred way before she passed away. Now, on the day in question, which is very, very difficult for me, because standing here requires me to relive the painful day of burial of our mother. It will mean for me today that I'm burying her for the second time, because I have to relive that painful day through my testimony. On the day in question, my security came in the morning to take the vehicles to a road lodge at Grayston, where there will be sweeping of vehicles which are going to the stadium.
When you say a road lodge, you mean the city lodge? It's a
no,
hotel?
road lodge.
Road lodge.
Road lodge. I should indicate that it was very few vehicles were allowed at the stadium. Even ministers' vehicles were not allowed at the stadium. Only those ministers who were in the preparatory committee were allowed to come with vehicles to the stadium. There was a shuttle service provided on that day where ministers will park and get into buses. But my vehicle was swept that day by the security and then allowed to proceed with the escort of the Metro Police to the stadium.
When you refer to your vehicle, what type of motor vehicle was it?
Viano, the black Viano Mercedes-Benz. When we arrived at the stadium, we did not park at the parking. We parked at the basement where the presidents and former presidents and head of states were parking. And the program proceeded, and after that, it was announced that very few people will go to the cemetery, and the rest of the mourners should remain at the stadium, and those accredited should go to the cemetery. I was standing with Minister Mbalula that day when my car came to pick me up. Just we walked outside the stadium and my car came from the basement to pick me up. And he was shocked that my car was allowed because they were made to park somewhere as ministers and go into buses. I'm making this point to demonstrate how the vehicle in question has had access to where nobody had access. We drove to the
When you say we drove, who was with you in the vehicle?
It was me and Mr. Ndlozi.
Accused number 2?
Yes.
Yes.
And the 2 protectors.
So in total, how many people were in the vehicle?
4.
Okay.
Now, it was so tight, the security was so tight, so much that no one could actually join the convoy if you're not accredited. Your Worship, when we joined the freeway, the off-ramps and the on-ramps were all blocked. And the on-ramp that we came from Orlando Stadium, where the N1 starts from that on-ramp, that blocked it. No car coming from the other side of that on-ramp will pass that on-ramp. Only the cars of the funeral were allowed on that day.
Now, amongst that convoy, were there any motorcyclists?
There were motorcyclists, there were Metro Police, there were all types of law enforcement on the day. I think I had just asked one of our colleagues to go and print just a example, a picture of the freeway that day where the presidential convoy and all of the convoy, it was only those types of vehicles on the freeway on that day. So we proceeded. We never had any problem. And we arrived at the entrance of the cemetery and were blocked by Colonel Venter. It is incorrect for the other witness to say he blocked us before, because we're never blocked by anyone. Even in my original statement, I make mention of Colonel Venter blocking us. Why would I have missed that one? I didn't know he was going to be a state witness. I had nothing against him. I would have mentioned that we were actually blocked first by this person and then second by Venter. We're never blocked by anyone. We're blocked by Venter.
Now, at the time when you were blocked by the complainant, where were you seated in the vehicle?
I was at the back. Now, Venter blocked us. Then he spoke to our driver. Our driver showed Venter the permit of the car and showed Venter his accreditation, the individual accreditation. Venter asked our driver a question: who are you driving? He said, Mr. Malema. I think that's where the problem started, because he said, no, you are not allowed. Now, my worship, if the truth is being told, we live this life every day. It's our job. If the vehicle is not allowed and only individuals are allowed, Venter would have said, drop off here and take the car to park on the other side. It's our life. We do that on a daily basis, where we are told the car will not go in, drop off here, take the car back. No. Only to arrive in this court and hear that my car was a problem. But all along, I lived under the impression that I was a problem who was not allowed to attend that funeral. My car was never questioned on that day. No one ever had an issue with my car. After they told him, and he said, no, this car will not go in, I then got out, because I thought if he recognizes me, he will change his attitude. When I got out, he did the craziest thing I've never seen in a police personnel. He blocked the car with his body and stretched his hands like this. He was blocking the car like, and I was like, why are you being dramatic? What is the problem? And he started speaking in Afrikaans. And that's when I started being agitated. Your worship, it was a difficult day for me. It was an emotional day for me. Any attempt to stop me from burying my mother will be a humiliation and violation of my dignity as an individual. I was not going to reason with anyone who will want to stop me from burying my mother. I did everything to bury this woman in a dignified manner. I lived with her. I defended her when they all turned against her. And I was not going to allow a situation where I'm denied the right to say my last goodbyes. If they had said to me, your car is not allowed, get out of your car and go walk into the cemetery, I would have done that, as long as I can just get an opportunity to bury my mother. But when I was denied, despite displaying accreditation, despite being known who's very close to this person who are burying today, I still get treated in a manner Venter did. Now, we are now pushed. There were guys who came, and those were, the passerbys, who said, hey, what are you doing? And then they started pushing him. You don't know this guy. You don't know this guy. They started pushing him. Then I went into the driver's seat, because I said to the driver, look, if you are scared to drive, let me drive this car. It's my car. As I was trying to drive the car, then Venter continued with his shenanigans. I then went back and then I pushed him. I said, you need to leave my car. Your worship, the question should arise. If a police officer is being pushed, executing his duties rightfully so, the first thing a police officer does is to call for a backup. Did Venter call for a backup? No way does anyone argue that Venter called for a backup because he was under attack. If anything, he was acting on his own out of his hatred of some of us, maybe because later it came out that he's an AfriForum member, an AfriForum which is an enemy of my organization. So we pushed him, and then we came in with the vehicle, and everything proceeded so well. Now, let's canvass this one, Your Worship. If the car is not allowed to be there, under no circumstances, particularly in the presence of the president, former heads of states, and heads of states, will that car have access? It will never go in. Because what is the point of taking these cars through screening if there is a car that can just bull itself into the occasion? It's a security risk, and it's a high security risk. Let's say we succeeded to push our way at the entrance. I can guarantee you, Your Worship, we're going to be fetched from our inside that this car does not belong here. You must leave with this car with immediate effect. It's a Venter's attitude. It's not police operation. Police operate in a particular way. And one of such ways is no car which is not accredited in an occasion like that can have access into the cemetery, and there is no follow-up to go and impound it. And what is even worse, Your Worship, is that in such occasions, you will have a tow truck where if a car parks at the wrong place and they can't locate the driver, they tow it. If a car goes inside and the owner is cheeky and not compliant, they will tow it. Nowhere, Your Worship, are you told of this car being towed? Are you told of this car being impounded? Are you told of police reinforcement to come and deal with these unruly elements? It's only one man in such a big occasion where he acts on his own volition without following what are the prerequisites of a person who must mend such an occasion.
Mr. Malema, over and above the car.
I've got a bit of flu. Can I have
through
you, Your Worship?
Yes, you may.
Yes.
Over and above the car, if we sketch the scenario that you've now depicted for this court, had you, in the minds of all of those officers, police officers, and all other corps, assaulted a colonel in front of all of them, ordinarily, what do you believe ought to have happened to you?
I didn't hear that.
Had you, in the minds of all the officers that were present, including high-ranking police officers, members of the military, if you had, in their mind, assaulted the complainant in front of them, what do you believe would have happened to you?
We will have been arrested immediately on the scene. There would have been enough police presence to show us that you don't dare undermine the police proceedings, because on such occasions, Your Worship, police take over. Once they say it's a state funeral, both the army and the police are in charge, and therefore no one will dare undermine such authority.
I want to hand you Exhibit A before this court. Can you identify this document, please? What is that?
Special official funeral service for Winnie Madikizela-Mandela, Saturday, 14 April 2018, 26 September 1936 to 2nd April 2018, with Mama's picture.
No, I believe it's common cause that was the official program of the day, and you'll see there that you feature as item 17. Do you identify yourself as being the presenter in item 17?
Yes.
What did that entail? What were you required to do?
I was expected to pay a tribute to Mama Mandela.
So if anybody said that you didn't belong at this funeral, shouldn't have been at the cemetery, what is your response?
That is unthinkable, because even if I was not on the program, there are a lot of Winnie's relatives, there are Winnie's grandchildren who were not on the program. But there is no way you can think they will not be at the burial site. It is unthinkable.
Now, in the docket, there was a statement by the late Ambassador Zinzi Mandela. I'm going to read it to you for your comment. It was A24, it's Exhibit E in this Honourable Court. It's a statement by Ambassador Zinzi Mandela. I, the undersigned Zinzi Mandela with identity number, wish to state as follows. I'm an adult female South African citizen at present serving as the South African Ambassador to Denmark. I'm the daughter of the late Nomzama Winnie Madikizela-Mandela and the late Nelson Rolihlahla Mandela. Both my parents were renowned and internationally acclaimed political leaders who played a significant role in the struggle for the liberation of South Africa from the yoke of apartheid. My father died on 5 December 2013. More significantly, relative to this statement, my mother died on 2 April 2018 and was buried at an official funeral on 14 April 2018. I was shocked to learn recently that Mr. Julius Malema was on the verge of being criminally charged for being involved in a scuffle with Lieutenant-Colonel Venter of the South African Police Service at the gate of the Fourway Cemetery on the date of my mother's funeral. I was even more appalled on the day in question when I was told that some members of the South African security forces who were an official at duty at my mother's funeral had attempted to prevent Mr. Malema from entering the cemetery to pay his last respects to my mother, who literally raised him and regarded him as her own biological child and son. This is the fact that is or should have been known to any person who regards themselves as South African. In any event, any security briefing preceding the funeral ought to have been identified as the most obvious members of the Mandela family, including our extended family. It was no coincidence that Mr. Malema was one of the key speakers at my mother's funeral. Despite some political resistance, the Mandela family had insisted that Mr. Malema be part of the program. Without him, the funeral would have been incomplete or carried out against the wishes of the person being buried. Again, any member of the security forces ought to have been briefed about or be in possession of the program. To prevent Mr. Malema from entering the cemetery would have created the most serious violation of the specific wishes of the Mandela family. To prevent a son from burying his own mother in the name of the law is an unthinkable act of provocation. There was in any event no justification for attempting to block Mr. Malema from entering the graveyard. More importantly, I wish to appeal to the humanity of those who will take the decision whether to charge or not charge Mr. Malema for his role in the scuffle which took place in those special circumstances. I also wish to appeal to the decision makers' compassion and empathy. At the relevant time, those of us who were the closest to the deceased could not reasonably have been expected to behave as our normal selves. Understandably, we were not ourselves. We were caught up in a bizarre and unprecedented moment. An armchair approach after the fact cannot even begin to appreciate the uniqueness of that moment. I myself would have reacted far worse if any person had prevented me from paying my last respects to my deceased parents. It would have been culturally incongruent and morally indefensible. Laws cannot be applied mechanically as if we are not dealing with human beings who suffer loss in different ways. This is an incident from which all those involved should walk away with their dignity intact. The purpose of this statement is to express in the strongest possible terms that Mr. Julius Malema cannot be justifiably prosecuted for that which we would all have done, if not worse, under the circumstances. I therefore plead that the decision to prosecute ought not to be taken. Failing this, the Mandela family will have no option but to doubt if the security forces had the interests of the grieving family at heart. To charge Mr. Malema can only serve to exacerbate the pain and sense of loss which we still feel and will represent the height of insensitivity and absence of Ubuntu that makes us human. As a family, we would support any alternative solution which does not involve the criminal justice system, including attending a meeting with the alleged victim, so that we can explain the deep human and cultural issues involved in this matter, which cannot be treated as a routine case of assault. For any further clarity on the above, I can be contacted at the following email address, and it's supplied. We pray that sanity and common sense will prevail in the handling of this matter, and it's signed by Zinzi Mandela on 14 September 2019 in Copenhagen, Denmark. Do you have any comment on that statement, sir?
Well, I agree entirely with that statement, and that Your Worship should note that in the spirit of that statement, we also tried to approach the complainant, because we are not boastful about what happened. If anything, our mother's funeral was supposed to proceed incident-free. And when this came to the fore, we thought the best thing will be to approach the complainant, and we find the Ubuntu solution to this problem, which the court should encourage. That instead of preoccupying the court on matters that could easily be resolved amongst individuals, particularly matters like common assault, we should all be encouraged to do Ubuntu approach.
It was admitted by the complainant that he never attended that meeting. He sent AfriForum to attend that meeting. Do you have any comment on that, sir?
Well, that's how political it becomes, because AfriForum has made its business to go after me and go after the EFF. So I'm not shocked that they actually denied him to do the right thing, except AfriForum being Mandela's fans. They are fans of Mandela when it suits them, but when it doesn't suit them, they are not fans of Mandela.
Just one moment. Just one moment. Sorry to interject, Mr. Otis. The court just wants to remind that the pandemic is still being regulated by the Health Act, and I now see everybody is realizing that they do not wear their mask over their nose. Advocate holders, as well as Mr. Malema, doesn't have a mask on because it is necessary for them to lead evidence in this regard, and Mr. Malema have clearly requested the court to do so. Members of the gallery have not requested the court to remove their masks. So, inspectors, I am requesting you to look specifically at the people should wear their mask at all time whilst they are inside of the building. If they do not wear their mask, they are free to leave, and then they can remove their mask at their own wish. But whilst this proceedings is continuing, the court is expecting everybody to wear their mask. Sorry for the interjection, and the court do not want to repeat this in future again.
I appreciate that. Thank you.
May proceed.
Yes, Your Worship, please. Thank you. Thank you. Now, sir, I want to turn to the time that you were leaving the stadium. You have said that there was a cavalcade or a convoy of motorcyclists with the vehicles. Is there a video presentation of that you've seen anywhere?
No. But also, Your Worship, is that I hear people saying our vehicle was the last one. It's not true. Because our vehicle, if it was the last one, then there will be the last police vehicle, either Metro Police or the bikes or anything of that. So there is a lead in front, and there is a car which blocks people from joining the convoy. So our car was not the last one.
Now we see the video, and you'll notice immediately there are no motorbikes or motorcyclists on the video. Do you know where they were at that stage?
The first ones would have entered, and the last ones are still coming. So that's why you can't see them immediately after our vehicle.
If the video had started earlier and ran for longer, would you have seen that?
Well, they should be able to show us. It should be able to show us. And equally, I don't understand this thing of bringing cut and paste. Because for us and for the worship to arrive at a determination, he needs to have a total picture. And this is not a total picture. It's part of the picture, yes. The fact that it's not being disputed, it doesn't mean it's a total picture. We have accepted it to be accepted as evidence because it's part of what transpired, but it's not a total picture. And therefore, any judgment that relies on this video, it will not be relying on the total picture of what transpired on that day.
So when you say it's part of, what you mean is that it's a portion of the proceedings. It's
Absolutely.
not- Thank you. I'm going to turn to the video now and play it for you, starting at the beginning. It's an exhibit before this court. And then I'm going to ask you for your comments as we proceed. Now, you see cars driving in. Do you recognize that as the entrance?
Is this way starting?
Yes.
Yeah, you see that's extreme distortion, because I don't know if they brought the picture, Lawrence. In the front of the convoy, let's leave us, because someone is trying to prove that we infiltrated the convoy. The first picture we must see here is of the motorbikes and the president's vehicles. So anything that starts with an unidentifiable C200 Mercedes-Benz is nothing close to what the president drives.
So we see these unmarked vehicles
Yes.
driving in. Do you agree?
Yes.
The time that's given is at the top left there. It's the 14th of April 2018 being a Saturday, at 15:15 being the hours and the minutes and 25 seconds. I beg pardon, 15:45. Thank you. I was corrected by my learned friend, and she is correct, my lord, your worship. So I'm going to proceed. So you see these unmarked vehicles entering. There was a Mercedes, and now there appears to be a Volkswagen. Do you agree with that?
If you have noticed,
And those vehicles
so to create an impression that convoy means bumper to bumper is there it goes for a very long time without any car coming. Then impression is, no, it has to be bumper to bumper, it must have blue lights, and there must be sort of identity, which you can't see from those vehicles that we just watched now.
This is camera 11. It's already inside the gate. Here comes the BMW X5. And another one.
So you see these ones, they are likely to be driving together. So that one, first one might be the main car, and the one close to the bumper might be a backup. That's why they've got blue lights.
But now you've seen, as you've pointed out, the gap between that Volkswagen
Yes.
and these BMWs. Can anybody, or I want to ask you, was that Volkswagen part of this convoy and granted entry to the memorial place?
It was. It was.
To carry on.
The being part of the convoy is not determined by blue lights and then entering seconds after each other. It's incorrect.
And thus far, for the record on this video, have you seen any motorcyclists?
No.
Okay, I'm going to proceed.
And the likelihood why you don't see the motorcyclist, this is the body of the convoy. There is a head and a tail. That's where you get more, the escorting cars.
Now,
You
these
get them-
two X5s, you saw blue lights. Do you see any other depiction that they've been authorized to enter? Any
No.
signs on them or permits or anything visible on the
Nothing.
video? I'll continue. This is camera 11. There's another camera of outside of the gate. This is inside of the
Okay.
gate.
But again, have you noticed the time that X5 has been standing there and no other car coming immediately after it? Because impression here created is that for you to be convoy, you have to be bumper to bumper. And I said those two are bumper to bumper because the other one is the main car, the other one is a backup.
That's the incident. And just for the record, whilst you're watching, the whole group of people in uniforms visible on the video. Do you agree
Yeah.
with me?
Yes.
Now you see there, it's the beginning of the incident, the red umbrella with the EFF insignia. Do you identify it?
Yeah, I see the red, I don't see EFF emblem.
Pause. Do you identify yourself there?
Yeah.
And accused number 2?
Yes.
And what are you doing there?
I was pushing Venter
Why?
to move in front of my car so that my car can go in. Because he had no justifiable legal reason why he stopped my car.
And the car, what was the car doing while that was happening?
Huh?
What-
The guy is driving in.
And is anybody else
No one is
prohibiting that
blocking
vehicle
it.
from entering?
No one is blocking it. And there is too much police presence there and other law enforcement officers. Why is Venter giving himself the sole responsibility of stopping that vehicle? If that vehicle indeed was not supposed to be there, as we're busy with Venter, other police officers should be attending to the vehicle. Or hey, wait, we're still attending to this matter.
Now in the screen you can count. There are more than 12 people in uniform.
Yes.
Does anybody take any measure to prevent that vehicle from
No
coming
one.
inside besides Mr. Venter?
No one.
Right, I'm going to move forward. Now you see the state witness talking to accused number 2.
That one I'm very disappointed with. His statement and what he said here are not worth of a law enforcement
Well, let me
officer.
ask you, did that person stop your vehicle outside of the cemetery?
No, he never stopped my vehicle. Even in his statement, he doesn't say that, Your Worship.
And here,
If he had said that in his statement, I will respect him.
and here
but-
does he do anything to stop the vehicle from
No, he
proceeding?
doesn't do that. But to be prepared, to be coerced into saying wrong things under oath, it's a terrible thing to do, including for those who coerced him to come and disown his own statement. Horrible.
Now you see the complainant there. Does he seem to have suffered any injuries?
No, he's proper. You see, no one, Your Worship, is making calls or running or doing anything to get reinforcement to go after that car. That car goes inside without any problem. Now, Your Worship, our car is not part of the convoy. Lawrence, if you can stop it there. There. Your Worship, before our car came in between, we waited for a bit for us to come in. If you can check the distance. There is no traffic officers. It is their own evidence to you that the last vehicle of the convoy is the traffic officers or motorcycles or anything of that sort. Where are those motorcycles between my car and the one that went in before? And then now my car has gone in. The other car is coming after mine. Where is the motor vehicles that blocks the convoy, the last cars of the convoy? Where are they here?
You mean the tail of
to
the
show that this was not, to show that this was still a convoy and that my car was part of the convoy. Because immediately before me, there were supposed to be motorcycles. They are not there. Immediately after me, there were supposed to be motorcycles. They are not there. Meaning, the convoy is still proceeding.
Do you know this vehicle that's driving in?
No, I don't know. It looks like a hearse.
Now, can the hearse not? Can it ever be argued that the hearse was not part of the convoy?
No ways. No ways.
Now, even after the hearse, I'm going to show you for a while. Do you see motorcyclists arriving?
I see Venter on a walkie-talkie walking nicely.
I'm going to try to get the other view now outside of the gate. Don't know how to do it. Hold the batteries. I just need my learner friend's assistance.
It is in order.
No, I don't seem to have yet. Well, you've watched the video now, Mr. Malema. If we can come back to what transpired on that day. Once you were inside of this memorial park, what happened?
We attended the burial of Miss Mandela.
Did anybody come and approach you and
No
tell you
one.
you had no right to be there?
No one.
Did anybody come and tell you that your vehicle had no right to be
No
there?
one.
You and the other occupants of the car, did you have any personal authorization to be there?
We're hanging it on our chest.
What was that?
The accreditation.
And was that vehicle accredited?
The vehicle was accredited. There is a video which they showed here in this court with the accreditation on the dashboard.
I'm going to show you the photo.
Yeah.
I hand to you Exhibit 4. I'm going to ask you to turn in Exhibit 4 to page 4.6 and see if you can identify it. There's the program back.
I must go away.
The front page is 4.1. You'll see they're numbered and turn to 4.6. These are photos. It's common cause. They're photos that were taken out of the video footage that was available.
4.6. Yeah.
Do you see the vehicle?
Yes.
And is there anything that you wish to point out to this honorable court?
The second picture.
Yes.
If you look at through the windscreen, my worship, there is a accreditation there. What, there's no one who puts anything there. That's not a place to put a newspaper or anything of that sort.
The version changes. Firstly, is that a reflection or you actually
see a document? Yeah.
So,
I
attended.
What?
Did you or anybody else?
Why would we do that? And where are we going to get that from? Who's going to get that from? The colonel asked the guy to identify himself. He did that, showed him the name tag, showed him the accreditation. Then the second question was, who are you driving? And it was Mr. Malema. That's where the problem started.
Now, I know it's difficult for you, and you explained on your comments. Can you tell the court how you are feeling on that day?
It was a very difficult day, a very emotional day. I came into politics when I was very young, and I was raised by people like Winnie Mandela. I've been very close to her, and I could not have imagined that I would be stopped from burying her. My relationship with her, your worship, is known to all South Africans who are not ignorant. Only those who are ignorant and do not know what's happening in this country will not know how to relate with her.
So in that context, if someone told you that you weren't allowed to go in personally, what would your response be?
I was not going to allow that. You know, friends, you guys can find me guilty and send me to jail for years you want to. But if you are going to send me to jail for burying my mother, so be it. For Winnie, I can go to jail. For Winnie, I can be killed. I did that when she was alive, and I did that when she passed away. I defended her. So I seek no favor from anybody. I live by my principle. I did not violate any law. I wanted to bury my mother. I'm proud to have committed. Send me to jail if you want.
If someone said, fine, you were allowed inside because you had something, a lanyard around your neck, but that vehicle wasn't allowed inside, what would your response be?
No one told me that. I don't care about vehicles. I do not put attachment to vehicles. I'm saying to you, on a basis, you are told drop here and walk. I do that. That's part of my life. Why would I fight for a vehicle to go in? I don't care about the vehicle. I care about me being stopped from burying my mother. No vehicle. It stopped me. As long as I can bury my mother. That's what matters.
Was that vehicle authorized to enter that memorial?
It was authorized, and it went through security check. It was in the basement of FNB with president's vehicles, former presidents, heads of states. It was part of the convoy from the Orlando to the cemetery.
Were you and the passengers, all 4 passengers in that vehicle, allowed to enter that memorial center?
Yes, we were.
Now, I'm going to ask you, culturally, can you explain to the court the significance or importance of funerals and paying respects to deceased people? Culturally, what impact does it have on
Your
you?
Worship, you were going to deny me a closure. You were going to deny me a closure that I have no closure with the person I've known all my life. And in our culture, when you don't have such a closure and your things don't go right, you keep on blaming that occasion where you are not allowed to say goodbye to your loved ones. It's a ritual, but also it's a healing process. It's a closure. And nobody was going to deny me from having a closure. Uncultured people with no tradition may not understand that. I accept, but this is who we are.
Right, I haven't seen the photograph that I haven't received. I have seen, but I haven't received the photograph that you referred to, but I'm reluctant to delay issues. Can you explain to the court what you... I beg your pardon. Doesn't give me...
You made the approach.
Now, look at it and show it to my learned friend, because I haven't seen it as yet.
Sorry, Your Worship, I am going to object with all due respect. I have not seen this.
Also,
Just before you do object, I think Ms. Oudis wants to approach you as well and disclose to you. I do take into account it was not disclosed.
Bishop, I've in court now received 3 photographs that I'd like to show to my
At this
learned
stage,
friend.
Advocate Johannes, I've also noticed the time. It is 1
I beg your
o'clock. I
pardon,
think
sir. I
most
didn't know
probably
that.
it would be an appropriate time for you to go through the photos as well, and
Thank you,
then
sir.
also disclose it to Ms. Hart.
As your worship, please. Thank you.
At a later stage, you can the parties can inform the court how they want to deal with the said.
Thank you, Worship.
Thank you, Mr. Malema. You're still under oath. You are not allowed to discuss your evidence with anyone. You understand?
Yes.
Thank you. We will adjourn for the lunch break and we will return at 1:45.
As your worship, please.
You may stand, Mr. Ndlozi. Court adjourned.
That's your cavalcade. No, but I'll explain to you where it comes from. If you look on YouTube, I'm going to show you. If you Google the Winnie Madikizela-Mandela funeral procession, just a line up. Because I'm ending the phone. Yes. Yes, yeah, it's good. When you see what's going on, it's good.
Correct?
Yes.
Thank you. Mr. Ouders?
It's my intention to introduce 3 photographs of the convoy on that day. And the relevance, Your Worship, appears from the cross-examination of Mr. Venter. I understand my learned friend is objecting. If she wants to place her objection on record, we took this off the, if you Google Winnie Mandela's funeral procession, these are photographs from that website that were created whilst I was in court. I didn't have access to them before. I understand she has an objection to it.
Thank you. Mr. Hart?
Thank you, Your Worship. I indeed have an objection to these photographs being used. Your Worship, as I said, before I place the basis for my objection, on record I have said to Advocate Holders that when he wanted to present it, Your Worship, that is when I became aware, and when the accused testified that there's photographs, Your Worship. So I was not made aware of this before, Your Worship. And I'm going to object to the photos being used today, Your Worship, on the basis of documentary evidence. This is an enlarged photograph that I can see. And in terms of the legislation, Your Worship, authenticity needs to be proven, Your Worship. Originality needs to be proven. If we go on terms of Section 15(1) of the ECT Act as well, Your Worship, provides for the general admissibility of data messages. It is important to note that Section 15(1) does not make every data message admissible, and the wording of the section indicates that data message may be inadmissible on grounds contained in other laws. Your Worship, these photos that is enlarged, Your Worship, I cannot see any date or anything, Your Worship, on these photos. So I believe that my learned colleague should then prove authenticity in this matter, Your Worship. Please, the court.
Your Worship, I explained where I got them. I can't take it further. What I will do, Your Worship, is I'll avoid using them. I thought they would have assisted the court, but I can deal with this issue without the use of the documentary evidence, if I may proceed on that basis.
You may do so.
Thank you. Mr. Malema, it was put to Colonel Venter on your behalf that if you look on SABC TV or YouTube, it would appear that the convoy is much larger than he had told the court. Do you have any comment? Yes, the reference is page 5 of the transcript of the 29th of October 2020. It starts from there.
I agree.
Right. Now, I want to put to you that if you can give the court some indication of the amount of vehicles in the convoy and the types of vehicles that were in the convoy.
Well, there were different types of vehicles. The president was there. 2 former presidents were there. And the former deputy presidents were there. We had other heads of states, some of the ministers and deputy ministers and dignitaries. And there were buses assigned to family members as well, which were part of the convoy. So you can imagine how many cars are there, especially when you've got former heads of state and heads of states and former deputy presidents.
Now, you refer to buses. Do you mean mini buses, large commercial buses, or both?
Buses, even both. You can say both, but in this case, I was referring to proper buses that were some used for shuttling the ministers to the stadium and from the stadium to the gravesite.
In that page 7, it was put to Colonel Venter that even after 1600 hours, once these vehicles arriving from the stadium, white vehicles that it was put to him a part of the funeral parlor, and he said there were also military vehicles that were white. Do you have any comment?
There were military vehicles that were white, yes.
Right. And then it was put to him that your vehicle was part of that convoy. What's your comment in that regard?
I was part of that convoy.
Were there any motorcycles in that convoy?
There were motorcycles in front and at the back.
Were there any that also that traveled alongside besides
No.
the ones in front and the back?
No. The picture that they are refusing you to introduce to court for purposes of denying me justice will show you that there are no motorcycles in between.
Is there anything else that you'd like to tell this court about these charges in this incident?
Well, I think that these charges emanate from white supremacism, where a white Afrikaner male feels that his ego, a fragile ego, has been taken. Police get pushed all the time. And if police were to open common assault cases against people who push them when they execute their duties, you can imagine that these courts will be overcrowded with unnecessary cases. So if this does not come from white supremacism and hatred of certain people, why did you refuse the Ubuntu approach? Because if you're seeking justice, engaging one another to show each other's fault and perhaps for others to accept that they were wrong to do what they did, it is also justice. AfriForum is at the center because its responsibility is to spread hatred and divisions amongst our people. And that's why I'm not shocked. But what shocks me is the National Prosecuting Authority that coaches witnesses and make them change statements. As to where that emanates from, I do not know, except that I will suspect that it's a...
I'm going to object to this line of questioning where the accused is now saying that the NIA coaches witnesses, Your Worship.
It's not a questioning, I'm answering.
To the magistrate.
As well.
Can I just say?
Look at who destroy such characters. with such a person, unless you feel that an injustice is being made against you. Realize you've got nothing else but to defend yourself against an injustice.
Thank you. I have no further questions, Your Worship.
Thank you. Cross-examination?
Thank you, Your Worship. On the 14th of April, 2018, is it correct that you were in the black Mercedes Vito? If you cannot hear me, you can tell me, I can speak louder.
I didn't hear that.
Okay. On the 14th of April, on the day of the incident, is it correct that you were in the black Mercedes Vito vehicle?
Yes. It's not Vito, it's Viano.
Viano, okay.
Yes.
You've seen the video footage. Advocate Holders has played it for you. The black vehicle that is shown, you were in that vehicle, is that correct?
The Viano.
Yes.
Yes.
Okay. Is it correct that you were sitting at the back?
Yes.
Is it correct that accused number 2 was the passenger next to the driver?
There were 2 protectors in front, and then accused number 2 and myself were at the back.
Were at the back, okay. I'm going to play the video footage for you.
Sure.
Sorry, Your Worship, I just want to take the
Yes, you may.
try to get this away. Do you agree with me? I'm going to play it again, just here. I see blue lights on the BMW X5. Did you see that?
I saw that.
Okay. Do you see the blue lights on that vehicle, the second X5 as well? Okay. At 1547, I'm not sure if you can see, Advocate Holders, you can say if I'm correct or not. 1547.
I can see.
Okay,
My eyes are still sharp.
that's very good. .548. 1548. The vehicles are moving. The two vehicles. So 1548, 11 seconds, 12 seconds. At this point, you agree with me there's a gap?
Yes.
You agree with me no vehicle is coming at this stage?
Yes.
Thank you. It's 1548 and 21 seconds. You agree with me there's no vehicle still coming?
Yes.
We are now at 1549.
Absolutely.
You agree with me?
Yes.
Minutes, okay, 60 seconds. Oh, let me just move. I'm going to stop there. Okay.
Yes.
Now, can I ask, you were in the vehicle. When Colonel Venter stopped the vehicle, to whom did he speak to?
To the driver.
To the driver. Did he go to the driver's side?
Yes. But Your Worship, let me drive a different point home, which she's not doing. She's asking me, from this minute and this minute, can you see there's no car moving? From this minute to this minute, can you see there's no car moving? You know why the car is not moving in between that car and my car? Venter stopped my car. It's not in the camera. That delay is caused by Venter, who has stopped my car. Because if you're going to use that to determine that I was not part of convoy, then it's misleading. My car was stopped. Then what happens after? You will see a fracas to show that there was some form of discussion off camera. That's why there is a gap. And that discussion did not lead anywhere. And then the fracas started.
I'm going to go again to my question. Colonel Venter went to the driver's side, is that correct?
Yes.
Okay. So he spoke to the driver?
Yes.
Did you hear when he spoke to the driver?
Yes.
Okay. What did he say to the driver?
He asked the driver to show him the accreditation. The driver showed him the accreditation on his chest and the vehicle accreditation. Then he asked the driver, who are you driving? Then the driver said, I'm driving Mr. Malema.
Okay. So did the driver show his, I'm talking about the driver now,
Yes.
did he show his accreditation, or are you saying that it was around his neck?
Yeah, the one
Okay.
around his neck, he showed that.
And the vehicle accreditation?
Yes.
Did he take it out, or did he just
No, he
say
just
on the
pointed
dashboard?
it there.
He just pointed it
Yes.
there. Okay. I am going to show you before I move on. Advocate Holders, I'm not sure if you still have that picture, Advocate Holders, of the accreditation that you gave him. Can you just give it back to him, please?
Joseph, it's Exhibit 4.
4.6.
Flip it together, Joseph, because mine's not stapled. I
Yeah.
don't understand.
The record also to be correctly reflected. The question is concerning Exhibit 4.6.
It was 4.6, huh?
It's at page
4.6.
I'll reference turn to so that you understand.
That is correct.
Thank you.
When the driver showed Colonel Venter the accreditation, was he talking about that accreditation?
Yes.
Okay. You agree with me in that photo that you have on the dashboard, can you see any writing on there?
No, you can't.
You agree with me it is a square white object on the picture that we have in front of you?
Your Worship, this is an image from a video camera. And therefore, when you make an image out of a video camera, there's no way it can be explicitly clear. It's given. And therefore, even if I don't see the letters written here, we must accept how was this picture generated. And if it was generated from a video, then we know it can't be visible here.
I want to ask you again, on that picture
I can't
there,
see.
on that, you can't see,
I
thank
can't
you.
see what is written there.
Thank you.
Yes.
I'm putting to you that on that dashboard of that vehicle that you say is a permit, you say you can't see, but it looks like a square white object just on the picture. Do you agree with me?
I put it to you, I was there. I'm an eyewitness. I'm not hearsay. This was a permit put on the dashboard. And ordinarily, Your Worship, vehicle permits are put on the dashboards. But if you have never been a VIP, you will never understand what we're talking about.
I'm going to put it to you again. On that photo that you have in front of you, sir, putting it to you again, the object that we can see there, you said you can't see any writings on there, give you that. What we see there is just a white square object.
What I see here, Your Worship, it's a permit. Why? I'm an eyewitness. I was there. You see it on the pictures. That's not my fault. I was there. And the only person can be relied on what this is a person who was there, who is an eyewitness. That's how the courts work. Not hearsay and favoritism. I was there. What will this be if it's not a permit? Because if you look at ordinarily, I'm driving the same car. We can go to it now. There's nothing on the dashboard. Why would there be anything on the dashboard?
I'm going to ask this question again, and I'll ask the court to draw an inference. What I'm saying is, on the picture there that you have in front of you, that is evidence. On that picture, it is on there, it is a white square object.
On the picture here, Your Worship, is a permit.
How do you say it's a permit? You
I
can't
was
see any
there,
right.
I saw it.
But on that picture, sir, it is evidence.
You see, the problem is if you are there and you get to see something in the picture, you can relate. I can relate.
Okay.
You can't relate.
I am putting to you again, sir. None of us were there.
Yes.
You were there,
Yes.
Venter was there, all the other witnesses.
Yes.
Now I'm putting to you what we have in front of us as evidence. You say this, you can't see any writing, but on there, just looking at the dashboard, looking in the window, it is a white square object. That is the shape of the object. You agree with me? That is the shape of the object.
On the window is the
Yes.
permit.
Yes, but listen, it is a square white object. Am I right?
But listen, it's a permit.
I'm putting it to you again. It is a square white object that can be seen. I'm not asking if it's a permit or not. I'm asking the object.
I'm
That
putting
you
it to
see.
you. It's a permit.
You're not allowed to put to me anything, Your Worship. Can the
But I'm
court
doing-
please
I have-
explain?
Just one moment.
Thank
I have
you.
listened to the answers of the witness specifically when he says, I put it to you, but the court did not interpret it as a question that actually
Yes.
would require you to respond to the witness, but his answer is relating to answer your question which has been put to the witness. Therefore, I have not stopped it at all when you were asking. You may proceed, Ms. Hart.
May I proceed? Thank you, Your Worship. I will use it for argument. And that you say it's a permit, but in the picture that we have before us, it is a square white object. Okay. Did Colonel Venter speak to you in the vehicle?
No. He didn't speak to me.
Did he speak to accused number 2?
Accused number 2 is here, Your Worship. He will answer for himself.
I'm asking you were there, sir. Do you know or do you not know?
No, I'm not forced to answer that question. The accused number 2 is here. He will answer for himself.
Do you remember if Colonel Venter spoke to accused number 2?
Colonel Venter didn't speak to me.
Yes, now I'm asking
Yes.
you were sitting next to him. Was Colonel Venter speaking to accused 2? Do you know?
I don't know. Accused number 2 will speak for himself.
So Colonel Venter never spoke to you?
No.
Okay.
Remember, you said, did Colonel Venter speak to you while you were in the vehicle?
Yes.
I said no.
Yes, we are still there, sir.
Yes.
Okay. When did you move out of the vehicle?
When Colonel Venter blocked the vehicle in front, I got out so that he can see and perhaps recognize me. And only then did I speak to Colonel Venter, asking him what is he doing.
When you asked on your version, that is not what the complainant said, but on your version, you said that you asked Colonel Venter what is he doing.
Yeah.
Were you now out of the vehicle? Were you standing
I'm
on the front
outside,
side?
in front.
In front where he was, according to you, blocking the
Yes,
vehicle.
yes.
Were you standing next to him?
Yes.
And Colonel Venter's reply, according to you?
No, he started speaking in Afrikaans. I don't know Afrikaans. Then that's when I realized there's no cooperation.
At that time, you say you realized there's no cooperation, he spoke in Afrikaans. Did you ask at that moment to speak to his senior?
No, I moved, I went to the driver's side, wanting to drive the car myself.
Sorry. I moved, sorry, continue.
I moved to the driver's side, wanting to drive the car myself.
I can't find it.
And then when I was on the driver's side, I saw some passerbys pushing him and asking him if he doesn't know who this person is.
Okay. You did not ask then to speak to a supervisor of
No,
Colonel Venter at that moment?
Not at all.
Okay. When you say you wanted to drive the vehicle yourself, did you get in the vehicle?
No, I didn't get in. When I was about to get into the vehicle, then that commotion started. Then I went to him, and then I pushed him.
Who's him, Colonel Venter?
Venter, yes.
Colonel Venter, okay. You say, which I just need to understand, bypassers was pushing him. What do you mean bypassers? Who's bypassers?
Some people I can't recognize.
People that were there?
People who were part of the mourners. They could see that there is a situation there, and they recognized me. And then they asked him, don't you know who this person is? And then when he could not cooperate, they pushed him. Then I came back from the driver's side, and I said to him, stop what you are doing, and I started pushing him.
So you came back from the driver's side.
Yes.
You were no longer with Colonel Venter. You then came back,
Yes.
and you also pushed
Yes.
Colonel Venter.
Yes, to move away from my car.
And before you pushed, some other people pushed him as well.
Yes. He says that in his own vision, even himself.
It's fine, I'm going on what you are saying. So other people pushed him, and then you decided to push him.
I
also.
came back to push him or no, stop what we are doing.
And when you say pushing, did you use your hands like this? How did you push him?
I used my hands like this.
If the court can just note the demonstration, Your Worship.
The
That
court
was
have
made.
observed that the witness before court have lifted up both his hands in front of it and showed with the forward direction that he have pushed the said witness. So how does Ms. Hart?
Confirmed, Your Worship.
Ms. Hart?
And when these strangers or bypassers was pushing him, what did Colonel Venter do?
He didn't do anything. He keeps on blocking the car. I don't know whether he was being possessed or what, because Venter Because I've never seen police he blocked the car with his body, like this. He blocked the car with his body. You know, Your Worship, if we had a video of the outside before, because this one it starts showing where they are. It's a rail of the gate. If you will see the video outside, you will see what Colonel Venter was doing. He acted like a possessed person who was not reasoning at all.
Okay. So, these strangers are pushing him, you come back to push him. Is that correct?
Yes.
Okay. How many times did you push him?
I wouldn't know. You know, when there is a commotion, you don't say, I'm pushing, push one, I'm pushing, push two, I'm pushing. There's no such a thing. You can't count them.
So, you did not count, but you know for a fact you pushed him.
It's undisputed.
You pushed him. And that time when you were pushing Colonel Venter, did he do anything to you?
Yes, he keeps on charging.
Charging how?
Like when you push him, Your Worship, he goes like this, like pushing back.
Oh.
I see you are making movement regarding how we charge. Did he charge at you or back to the vehicle? At you.
At me.
Just for record purpose, this is how the court have observed when the witness says that he was charging, and it is then referring to retaliation to the witness before court. Is that correctly observed? Thank you.
So when you pushed him, is he just doing this with his body?
No, he's coming with his body. Like, the reason why he's pushing back is because he wants to stand in front of the car so that the car doesn't move.
Okay, so he just wants to stand in front of the car?
Yes.
Okay. Did he use his hands when you say charging or pushing? Did he use his hands to push you at all?
He never pushed me. He's using his body, refusing to move from the car. So you'll push him then he'll take 2 steps backward, then 2 steps forward again.
Oh, so he was not attacking you or any bystanders. He was just standing. He was refusing, according to your version, to be removed from the vehicle, the front part of the vehicle.
No, he was charging. Attack is something else, you know.
He was charging.
You don't have to attack. Sometimes you have to just charge by the body action. How you use your body can also be described as charging.
But
so when a person goes like, you can see that this person is not being friendly. So when I say charging, I mean he was not being friendly.
He was. Oh, you're saying now we need to have clarity on this charging, because now you're using the word he's not being friendly. Okay. You are pushing Colonel Venter.
Yeah.
Okay. Did he move a bit backwards when you pushed him?
Yeah, 1, 2 steps
1, 2
backward.
steps, and then he came forward again.
3
1 or 2,
steps forward.
3 steps forward. Is that what you mean by charging and his
Yes.
body?
Yes.
Is that what you mean?
Yes.
Okay, we just need to get that for the record, Your Worship. Okay, so Colonel Venter at that time never pushed you when he was moving 3 steps forward?
I've never made such an allegation.
No, I'm asking.
Yes, never pushed.
He's never pushed you. Okay. Now, you pushed him, he moved 2 steps back, 3 steps forward, he's there. We are there now. Okay? He now moving back 3 steps. Then what happened?
Then I think accused 2 and one of the protectors and those other people who were there, they all came. And then when he saw a lot of people now pushing him, he now started going back. He was no longer coming forward. I think he was realizing that he's actually attracting more people. And then we pushed him to the side.
Okay. So, let's go back. Where you see the accused number 2 and the protectors, they all came. If you say they all came out of the vehicle.
Yes. Not all protectors. The driver was there.
The driver. So, okay.
There was no one in the vehicle that time. It was only the driver.
Only the driver. So accused 2 came out of the vehicle. How many protectors came out of the vehicle?
1.
1 protector came out of the vehicle. Yes. They all came. And when they came out of the vehicle, what is the protector's name, or can you use his name?
No.
Okay. So this protector and accused number 2, they came out. When they came out of the vehicle, what did they do?
No, they came to join me and these other people who were there. And then we all started pushing him. Remember here we're talking about well-built, highly trained Afrikaner male. And now we're just the piece, small bodies. were pushing. And when everybody joined, including
Yes.
these people we don't know, to push him, only then did he move to the side.
Okay.
And he stopped resisting.
So accused number 2 also pushed Colonel
Yes.
Venter when he got out of the vehicle,
Yes.
and the protector.
Yes.
Okay. So when they were pushing Colonel Venter, did you also push again or did you not?
I pushed.
You
I was
pushed.
pushed. They joined me in the
So
pushing.
so the 3 of you that we know of, besides the bystanders
Yeah.
that we don't know, so the 3 of you and other bystanders, strangers, pushed Colonel Venter again.
Yes.
Okay. And when the 3 of you, with the other strangers, pushed Colonel Venter, did Colonel Venter push any of you or assault any of you at that time?
No.
Can you remember, if it's in your memory, if you can recall, how many more or less, besides the 3 of you, accused 1 and 2, and the protector, how many other strangers or bystanders were pushing?
I think we're, with us included, between 6 and 7.
6 and 7 people.
Yeah.
So when the 3 of you and the other people were pushing Colonel Venter, did you now push him away from the vehicle?
Yes.
Did Colonel Venter say anything while the pushing was going on, while you and accused 2 were pushing Colonel Venter? Did he say anything?
Venter was speaking in Afrikaans throughout.
So he was
So
speak.
I wouldn't pick up what he was saying.
So the first push, when you
No,
pushed him.
remember when I got out of the car,
You
I
were-
spoke to him, what are you doing?
Yes.
And then he spoke in Afrikaans.
Yes. But now
Then I left him, I
yes,
went to the other
driver.
side.
Yes.
When I was on the other side of the driver, the passerbys came and
Yes.
started talking to him and say, you don't know who this person is.
Mm.
He kept on talking to them in Afrikaans and they started pushing him.
Yes.
Then
And
I
then
came
you
back
came.
and then I joined them in the pushing.
Pushing, yes.
And then accused number 2 and the protector came.
Came.
And then that's how we managed to push him
Yes.
off the car.
Yes. I understand that. What I'm saying is, did he say anything? Remember, also, did he do anything back? He didn't
said
push you.
something,
Did he
yeah.
say? But when you were pushing him alone, when you went to push him alone, did he say anything to you at that time?
Yes, he spoke.
In Afrikaans.
Yes.
But you don't know what he said.
Yes.
Okay.
But very angry.
Very
You
angry.
could see the facial expression. I might not hear the language, but he was not sending love.
Okay, he was not sending love. Is that so? Okay. And when accused 2 also now came and the protector also pushing, didn't do anything, but did he say anything?
He
At
kept
that
on
time?
speaking in
Kept on
Afrikaans.
speaking Afrikaans.
Yes.
Okay. Okay. So, all 3 of you are now pushing him. When the 3 of you were pushing him, he was away from the vehicle.
Yes. We pushed him away from the vehicle.
Away from the vehicle. At that time, still, did you, when the accused number 2 and the protector came out of the vehicle, did you, at that moment, ask to speak to his supervisor or senior?
No.
Okay.
Not at all.
Do you know if accused number 2 asked to speak to his senior
I
or
don't
manager? Okay. But you did not ask. You did not ask to speak to a senior or
No, I
manager?
didn't ask to speak to any senior. But we spoke to those, I don't know what you call those uniform police.
That was standing here.
Yeah, these guys. We kept on asking them, why are you folding your arms when this white man is blocking us from attending Mama's funeral?
Okay.
Because you can all see that he's misbehaving.
Okay.
They all pleaded with us, please go back to the car, leave him.
So these in military uniforms, Navy uniforms, they pleaded for you to go back in the vehicle?
Yes, they are the ones that we spoke to. We didn't, by virtue of uniforms, we thought there is some seniority there. But they were all pleaded with us, please go back to the car, leave him. So these in military uniforms, Navy uniforms, they pleaded for you to go back in the vehicle? Yes, they are the ones that we spoke to. We didn't, by virtue of uniforms, we thought there is some seniority there. So we engaged them. We said, why are you not blocking this white man? Because you can also see, Your Worship, they are not joining him. They are just standing there because they are puzzled by his behavior. And we said to them, why do you allow this white man to stop us from attending Mama's funeral? And you are just standing there. They
Yes.
said, please, 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 just go back to the car and go inside.
Okay, but what I want to know from you, when the accused two and the protector joined in the pushing, at that time you did not ask to speak to a senior.
But Your Worship, I answered that question. The court must protect me. I said, I never asked to speak to any senior.
Thank you.
And I don't know if the accused number 2 asked to speak to any senior. I'm playing an open card. I've got
Thank
nothing
you.
to hide.
Thank you. Okay, so you never spoke to any senior. Okay. I'm going to play the footage for you. Just pause, Mr. Baba. The protector you're talking about, is it the person with the umbrella?
No.
Was he not the protector you're talking about? It's not him. Okay. Play, Mr. Baba. Stop quickly. Just go quickly. Just go quickly. Okay. Stop. Go quickly. Stop. I'm just asking to focus there. Just need to move to the mic. There's a person in between you and Colonel Venter, is that correct?
Yes.
Okay. So it seems Colonel Venter is moving to the side of the vehicle.
That's what I told you. When
You
you
pushed
push
him.
him, he goes back. You push him, he goes back.
But
That's what he's doing.
yes, but at that time he's now being pushed to the side of the vehicle on that side. Okay, continue, Mr. Baba. Stop. Okay, play. Can you play it in slow mode? It's too fast. Okay, it's fine.
Do you see where we are? We are there, and then we're going back to the car. We were at the car, away from the car, and then we're going back to the car.
We're gonna-
because that's what Fender is doing.
We're gonna get there. We're gonna play the
Yeah.
whole video for you. We are just on that side. Do you see that there is someone?
The police.
That's a police
Yes.
officer.
Yes.
You see that this police officer is holding up her hands. And now Colonel Venter is now moving on the side to the front. And you are now following again. Please don't say,
yes, yes.
Thank you. Stop, Mr. Baba. You are pushing him again there.
Yes.
Okay? Now, it seems that accused number 2 is now coming as well.
I see him there at the back.
Yes. Do you see that the police officer's hand is still up? Is she saying anything to you at that time? Can you remember?
I can't even remember that there were police there.
It seems to me that you were also angry. You see, you
I was
putting your
very
face-
angry.
Yes.
Very angry. And I had all the reasons to be very angry.
And you were also not friendly.
Yes, I
Yes.
was very angry.
Okay.
He had no reason to be angry. I don't even think he liked Winnie Mandela.
Do you know that Colonel Venter was trying to contact the VOC, the Venue
No,
Operation
no.
Center?
How do you contact the VOC with your hands like this?
No, I'm asking you.
No,
Okay.
he was not contacting any
He was
VOC.
not, and you heard when he testified, he said at that time that he was trying to get hold of the VOC in order to see if your vehicle can enter.
Okay, Your Worship, what are you doing contacting the VOC if this car has got no right, or these people, no right to enter there? There's no reason to contact the VOC. They either have the right or they don't have the right. So contacting the VOC is another defense mechanism which must not be accepted. Two things. You either, this car is allowed or it's not allowed. You don't call anyone. You make that decision alone. They never said, and he never said himself, that their instruction is if they are in doubt about a car, they must call VOG. There was never such an instruction.
You heard when Colonel Venter testified. I'm saying when he testified. On the evidence in court, he's saying that he's trying to get hold of VOG. You heard him testify that?
Yes.
Okay. Stop, Mr. Baba. You see now, you see the radio.
I don't see the radio, but I can see his hand is holding something there.
Is something.
Yes.
He testified it's a radio, it's a two-way radio. I asked him,
Yes.
that's what he testified.
Yes.
Now, he is, since this object, the radio that he said, it's now in front of him by his mouth. Okay. Now we can see also the facial expression of accused number 2. He was also very furious.
Yes.
Not friendly.
Yes.
Yes. So now, at that point, can you see what the police officer is doing? Yeah. If you can't see, you can
I
come
can
closer.
see. I can see. He's
Ah.
blocking the person with the umbrella.
Yes.
Yes.
Okay. And you can see from Colonel Venter's body language, he's not coming towards your side. He's at the side of both you and accused number 2.
He can't be trusted.
Yes, but I'm saying on the footage, sir.
Yeah, on the footage
Yes,
side, you know, the reality and the footage is something else, because as he speaks, we are not sure if he wants to come back to the vehicle or he's walking away. So we are acting to prevent him from coming back to the vehicle.
Okay. I'm going to go again.
Yes.
We are just going on the video footage. This is admitted. It's real evidence. So, at this moment in time, the accused has a radio in front of his mouth. The complainant has a radio in front of his mouth. Thank you, Mr. Otis. And his side is towards you and accused number 2.
Yes.
Yes. Okay. Play, Mr. B. Stop. Can you go a bit back? You are now pushing him against the wall, the
Yes.
guardhouse. There is still, just in his hand, the radio
Yes.
is still in his hand. Okay. Stop, Mr. Baba. At this stage, you are now, what are you saying? It seems you are very angry. I know you said a lot, but can you remember what you said?
That's unfair. I mean, this is how many years now? 4 years? I wouldn't remember what I said there.
You
It's a
wouldn't?
commotion.
But you were angry
Yes.
and you were shouting. Okay.
Yes.
At this time, you see that the vehicle is moving in the cemetery. Do you agree with me?
Exactly what we wanted to achieve.
The
By
vehicle?
pushing him aside to allow the vehicle to pass.
Okay. But at this point, I can see the military people on this side by Colonel Venter. Somebody is this person. Military uniform seems has his arms here by Colonel Venter. And the police is coming to accused number 2's side. You are pointing a finger. Okay. So everybody's face, so everybody's concentrating on what's happening with you, accused 2 and Colonel Venter. But while this is happening, play Mr. Baba, the vehicle is moving in. Who do you perhaps know at this point gave permission for the vehicle to enter?
Now, let's correct one thing. You say everybody is concentrating on us.
Yes.
And then that the guy next to Venter seemed to be putting his hands on Venter. A neutral prosecutor will say, who is not biased, will say the guy is holding back Venter because that's what he's doing. And therefore it takes away the story that everybody is concentrating on you. He's being held back because they've all come to accept that his behavior is unacceptable.
We don't know that, sir.
No, in the police practice is such that when a police officer is under attack, all of them join hands in defense of that police officer. They are standing there, they are not doing anything. If anything, your worship, they are holding him back because he's embarrassing them.
I'm so glad you said that because the 2 officers was putting up their hand in front of you, were moving as Colonel Venter is pushing. They were moving to the side of Colonel Venter. So they were trying to do something, sir, on the video footage. They were trying to intervene to stop the pushing taking place by you and accused number 2.
No, all I'm saying is that you can't see that Venter is being held back.
Okay.
That one you conveniently miss.
Okay, it's fine. But on this video footage, all we know is, we don't know who that person is, we don't have his testimony, all we can see is his hands is on Colonel Venter,
But-
on the video footage.
Okay.
Is that correct?
No, it's being held back because you see the problem, Your Worship, is that to play and stop, when you have stopped, it's no longer in motion. But when it's in motion, you can see that he's holding him back. He doesn't have to tell us he's holding back.
Okay,
We can see with our naked eye.
Okay, let's go back, Mr. Baba, and see if Colonel Venter is moving to you or moving forward. He's moving behind another
see?
person. He's still on the radio.
see?
There we go. Just stop there, Mr. Baba.
After you just said everybody's on us, all 3
Yes.
police officers are on him.
But let's move that. That was not my question. We will get there, sir. We will get there in time. What I'm saying here, you can go back, Mr. Baba, while everybody was dealing on the commotion side, this vehicle moved in. Do you know if the vehicle, if anybody gave the driver permission to enter at this time?
Yes.
Okay. Who gave permission, do you know?
No, SABS, when they approved it at the lodge.
At
and
the
then
lodge.
it went to the stadium and it went to the cemetery.
Okay. I'm asking only here, at this moment
You didn't need anyone to
in
give
time.
you the permission there. That permission is carried through.
Go back,
You
Mr. Baba.
require nobody's permission
Okay.
when you arrive there.
I'm going to put it to you. At this moment, just here, you can go back if you want, please, Mr. Baba. At this time, this vehicle is driving through. Let's look at the vehicle. He's coming. You are shouting. Cues 2 also. Colonel Venter's on the radio. There the vehicle stops. At this time, you can stop, Mr. Baba. I'm putting to you, at this time, while the commotion was going on, this vehicle just drove in.
Yes, because
Thank-
it had the right to do so.
That's what you're saying.
It required no Venter's permission.
Okay. That's what you're saying. But you do agree with me that Colonel Venter was in charge of the main gate.
No.
Was he not?
No, it's not for me to agree or to disagree. That's
But
what
I'm-
he says.
But I'm putting to you that Colonel Venter's job description on the day in question was to be in charge of the main gate. Can you dispute that?
No, I won't dispute it. It's your vision.
Thank you. So, like Officer Mapisa now testified, he is now there by accused number 2. His hand is on accused number 2. So, play wait a bit.
But let's clarify something here, Your Worship.
Okay.
Being in charge of the gate, it doesn't mean you issue out permissions. You are in charge of the gate to allow those with the permit to go in and those who don't have the permit to be given a direction to where they need to park. Colonel Venter never said to me or to the driver, drop off here and go that side. He never said that. So to be in charge of the gate, you don't issue permits. It's not your responsibility. So I don't know what it means to be in charge of the gate. Because once a permission has been issued, no one can stop it, including a person who's in charge of the gate. Your job is just to make sure accredited vehicles go in and those who are not accredited are directed at their relevant place.
Okay. You agree with me, Colonel Venter is standing close to the guardhouse?
Come again?
Colonel Venter is standing by the guardhouse.
By the guardhouse.
guardhouse.
Yes.
Okay. The 2 police officers, I see there's another police officer, play Mr. Baba, standing with Colonel Venter.
There are 3.
There are 3, yes. Play Mr. Bean.
So,
Stop.
Your Worship, if there was something wrong we're doing, there are 3 uniformed police officers. and there is Colonel Venter who is allegedly under attack, unfairly so, why would the police not act on us there and there? They are with him there, and the only reasonable suspicion would be they are saying to him, leave what you are doing.
Okay.
Because if we're misbehaving, I can tell you now, without any shadow of doubt, police would have pounced on us there and there.
Okay. That we will leave for now, okay? But you can play.
And there, one of the things I suspect we're saying is exactly what I was saying to you. You can see we're talking to those army people. We're saying to them, why do you allow him to misbehave? Why do you leave this white man to ill-treat us the way he's doing, and you are all here just standing?
Okay.
All they could say is, guys, please, 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 just go inside the car and go inside.
But you agree with me, Colonel Venter is now standing almost next to or close to the guardhouse. There's 3 officers standing with him.
Yes.
Female officers. And 2 of the female officers that we saw previously were moving as you were pushing. One's putting up the hand. It seems that this person trying to say stop, trying to intervene, but they were moving as you and accused were pushing Colonel Venter, accused number 2. Is that correct? They were moving along with you, accused number 2, and Colonel Venter. They were moving along as both of you were pushing him.
Yeah, but for a neutral prosecutor, when they put hands on us, they say stop. But when they put hands on him, they are just laying hands on him.
Okay,
What an
but
objective prosecutor.
it's fine. So we are talking
Can I
about
just
the
have order?
ladies.
No laughing in court.
We are talking about the 3 officers in police uniforms, sir. You agree with me? They were trying to intervene with the pushing.
They
of you.
did.
Yes.
They
thank you.
intervened.
Okay. Now Colonel Venter is standing there with the 3 officers playing Mr. Baba. Accused 2 is putting his hands on Officer Mapisa.
And
So
it was
Mapisa is escorting him
Officer
in the vehicle.
Mapisa who said here,
Pause.
accused number 2 kept on saying, why do you leave this white man to stop us from entering?
That is in evidence, sir.
Yes.
Yes. Okay. So do you see Colonel Venter is still standing by the guardhouse?
Yes.
There's a lot of the 3 officers who was next to him, one was standing in the middle, and then there was military people in front of him. You agree with me?
Yes.
Okay. Play Mr. Baba. At that time, before you got into the vehicle, in this vehicle now, did you ask at that time to speak to a senior
No.
of Colonel Venter? You did not ask. You got in the vehicle and accused 2 and drove in the cemetery. Don't say, just say yes.
Sorry. Yes.
Thank you. Continue, Mr. Baba. Did you speak, were you a speaker at the cemetery? At the cemetery?
No.
You were not a speaker
At the,
you
at
were
the stadium.
at the Orlando Stadium, but not this.
No.
You were not. Okay.
No. There are no speakers at the cemetery, by the way.
I'm just asking. It might have happened. We don't know. Okay. I'm going on your version, okay?
Yes.
What you are saying. Before you got out of the vehicle to speak to Colonel Venter, okay? You wanted to speak to him to solve the issue. You wanted to speak to Colonel Venter to solve the issue. Don't say,
Yes.
thank you.
Yes.
Okay. Was your life possibly in danger?
My life?
Yes. Your
No,
life,
my life was not in danger.
your life was not in
No.
danger. did it make you angry, according to your version, that a complainant, Colonel Venter, was speaking Afrikaans when you were trying to engage with him?
Not necessarily.
But you said you couldn't understand him.
Yeah, not understanding doesn't mean I will be angry.
Were you not
mean,
angry?
The white supremacists always speak in Afrikaans.
Always speak in Afrikaans.
Yeah.
Okay. Your life was not in danger. When you remember, you said you went to the driver's side. Don't?
Yes.
Thank you. Was your life?
You know, ma'am, sometimes when
Yes.
I say this,
Yes.
it's that I'm following, and
Yes.
then when you conclude, I will say yes. Yeah.
Okay. It's just, I don't
That
know.
is also, sorry to
Yes.
interject, that is also how I understand, because
Yes.
I'm also waiting for the question to finish before there's a response.
Yeah, so I just
But
go like
yes.
this so that when you finish, I say
Okay.
Just for record
Thank you,
purpose,
Your
I will
Worship.
not draw any negative
Yes.
inference from that aspect in this
I'm-
regard, because as I've indicated,
Yes.
that's also how I understood.
Thank you, Worship.
Ms.
I'm scared because I see him, and I'm not sure if he's saying yes, and then it's not recorded, Your Worship. That is the
Yes, we
issue
will
of the
wait for
record.
the conclusion
Yes.
of the question, and then we'll take
Okay.
it from there. Thank you.
When you went to the driver's side, you are going now back to Colonel Venter to push him. Was your life in danger at that moment, sir?
no, not at all.
Not at all. When accused number 2 came out with the protector to push Colonel Venter, the complainant, was your life or his accused number 2's life in danger at any point?
No. Our dignity was in danger.
Your dignity.
Our humiliation was going to be the order of the day. Our enemies will derive pleasure out of the fact that we were denied an opportunity to bury our mother. That was in danger. Our ability to have closure with Mama Mandela was in danger. And in our culture, everything else matters except the burial site. Your Worship, the most critical moment for any funeral is when the coffin goes down and you know that it is what it is and it will never change again.
Okay.
I will not have find it in me and forgive myself if I had not seen Winnie's casket going down, where I will say my last goodbyes. That was what was in danger. My
But-
dignity is equally important,
But
the same as my life is. So my life not being in danger, I cannot allow indignity to be directed at me, and I do not do anything in self-defense to defend my dignity.
According to Colonel Venter, and he testified you were here, he said that he had an issue with the vehicle that you were in, that the vehicle was not accredited, did not have a permit. And that is why he stopped the vehicle.
It is not correct. It moved from us not being accredited. Then it went to the car not being accredited. Then it went from the car, even if accredited, will not allow it to enter. Different versions on what was in dispute have been presented here by himself, which the court has noted during the judgment of 174.
Okay. So, you were talking about Ubuntu.
Yes.
Did you want to apologize at any stage to Colonel Venter?
No, I wanted to have a conversation with him, Yoshi, and ask what went wrong, what necessitated that, and if the need arose for me to apologize, I would have done that without hesitation. The same to him I would expect, of course, that if he realizes that he made a mistake, he will apologize at that point. But he refused that opportunity because his supremacism will not allow him to meet these monkeys.
Did you contact personally? Did you contact the complainant personally?
Once you have opened a case, it's always safe to use lawyers to contact the complainant, because I do not want to, Your Worship, be accused of intimidating the witness. So I used my lawyers to contact the complainant.
Okay. You agree with me that it is the complainant's right as a complainant in a criminal case for him to decide whether he wants to settle the matter out of court or go to court?
Absolutely.
Thank
It is his right, and it all depends also on our upbringing. We have never been taught to rush matters to court. When we were growing up, Your Worship, if we did anything wrong to each other, you will have the parents of the other one going to the house of the person who's wronged, or the other way around. Only when you can't find each other, you can then approach the police. That's what has made our society to be a unique society, where we are able to resolve issues amicably without the involvement of the police. But it doesn't take away the right that you have a right to open a criminal case. It's Mandela's spirit of Ubuntu, where he forgave people who took him to prison for 27 years. Why would you not want to forgive a person who blocked you from entering your mother's funeral?
But you agree with me, like you said, he has a right to open a case or not to open a case, or
Not
to
in
sort it out.
dispute.
Not in dispute. Thank you. I'm just going to go to Officer Mapisa
Yes.
that testified. He testified that your vehicle was not part of the convoy and that he stopped your vehicle.
He has never stopped my vehicle.
Did he not stop the vehicle?
No. Remember, Your Worship, I wrote a statement without knowing that Mapisa is going to be a witness here. And I indicated what transpired. And in majority of what I said, it's not in dispute. So if he had blocked my vehicle, I would have known and I would not have missed that opportunity.
But he said, what I find very strange, is that that is how he knew who you were. That is why he allowed the vehicle to go to the gate to Colonel Venter's side. Because he stopped the vehicle, he saw you were in the vehicle, he recognized you.
You know, my sister, Your Worship, it pains me that you will have an NPA that coaches people to behave in a manner that he behaved. Mapisa's statement, it's a true reflection of what happened, Your Worship. Why would Mapisa forget conveniently that he stopped me? He doesn't speak about any stopping of me in his original statement, to a point where the prosecution became so disparate and wanted to cross-examine their own witness. If we did not have smart lawyers who would have been shortcutted, and the next thing Mapisa made to denounce his own statement, clearly. And I think it's a matter that we should not leave lying down. A complaint should be laid, an investigation should be made as to what really transpired between the statement and the consultation that happened with Mapisa, where he comes here and denounces his own statement. He didn't denounce it anyway. He confirmed that his statement is a correct version of what happened, and still confirmed that his court version, which contradicts the statement, is a correct version. It's for the court to take a decision.
Yes, it's for the court, I agree with you. And he has explained why he said what he said to the court. He was cross-examined by advocate holders, and he gave an explanation to the court. Now, what I find just strange, sir, is the fact that he recognized who you were when he stopped you. He didn't look for any accreditation or any sort. He just saw you, and he recognized who you were. and without looking for any permits on your side, personal, that's around your neck, or the vehicle for any sort, he allowed the vehicle in just based because of who you are.
It's a pure lie. And that's what you should be worried about. Because even in the statement of accused number 2, there's nowhere where we say there was an officer who stopped us before, and then he recognized us, and then he released us. That can serve very well for our defense. That there was one person who was given a task of blocking vehicles. He blocked us. Upon realizing it is us, he released us because he's a black person, blah, blah. Then the white person stopped us. That could have been a very good defense for us. But because it didn't happen, we didn't mention it. You can look at my statement. You can look at accused number 2 statement. You can look at Venter's statement himself. Nowhere does he say, no, they were stopped before and then referred to me. There's no such a thing. He never stopped us. The stopping, I'm telling you, Your Worship, he was couched with it in consultation with the prosecution.
Okay. You've said that earlier. And I will move on because he has testified he just recognized you. He didn't stop you. He didn't ask for accreditation. He allowed you to move to Colonel Venter. And he also testified Colonel Venter was in charge of the main gate.
That is not in dispute.
Okay. And you testified as well that you've never met Colonel Venter.
Neither did I meet
Officer Mapisa.
Officer Mapisa.
Pisa,
Venter, I was meeting for the second time, Your Worship. I met him at the gate, and then I met him here. Mapisa, I met him for the first time here. I've never met him before.
Okay.
I've never met him before. Why would I lie about someone who stopped me and said to me, pass? It works in my favor. That why would another officer see it correct for me to pass and another officer not see it correct for me to pass, yet they are saving the same law?
Okay.
But equally, why would he miss such an important aspect of stopping us? Because the issue here, Your Worship, is us being stopped and us not cooperating. Why would he miss that in his statement?
That is for the court to decide. Argument will be given. Your attorney will know what to do.
It is also for me to bring it to the attention of the court.
So, but he has said and he's explained. And he said that he just allowed you in based on who you are. If he didn't stop the vehicle, he would not have known who was in the vehicle. And you agree with me on the footage that I've played, that your vehicle was behind the BMW X5s with the blue lights?
Yes.
Okay.
And I don't understand why do you only recognize the blue lights in the 2 vehicles when the vehicles that went before those 2 had no blue lights? You don't bring it to the attention of the court, objective and neutral prosecutor, that, Your Worship, there are vehicles that are passing, you can see them, they don't have blue lights. After these ones which don't have blue lights, they are the ones of the blue lights, then Malema without blue lights.
Were you, see that everything happened, the assault and everything that happened here on the day in question, were you late for the cemetery for the proceedings? When you went inside, remember the vehicle drove in, I'm just...
No, we're not late because remember the hash had to park on the side with the coffin. But it will be incorrect for us to arrive late because by the time the coffin comes, we should all be seated.
Yes.
Yes, so that's what we're pushing for.
Okay. But you were, so the hearse was still coming behind? Okay.
The hash was still coming, yes, with the parade.
So my question that I want to ask is, if Colonel Venter just wanted to speak to Vok or his superior or his senior to ask about the vehicle, he could have gotten an answer very quickly. I'm putting it to you, that would not have made you late. This whole, if Colonel Venter could have just called the VOC, got permission, none of this would have happened.
You don't need VOC. You need a permit. He doesn't have to call VOC. You either have a permit or you don't have a permit. And a decisive, disciplined police officer will tell you, go back. You are parking that sign. There's no need for VOC at all. So the story of the VOC doesn't exist. In the protocol of permits, you go for your car to be security checked. Once it's security checked, Your Worship, it can't even go to the garage. It goes straight to the designated area under police protection, which is what happened with us. Then we're dropped at the stadium. From the stadium, we joined the convoy under police protection to the cemetery. So we don't need VOC. You don't need VOC. Once a vehicle arrives there and it doesn't have a permit, it's going to be sent away.
But on this day, that is not what Colonel Venter is saying. I understand you explaining maybe what normally happens, and I get you. But on this specific day, Colonel Venter had an issue with the vehicle. Not you, not accused number 2. He had an issue with the vehicle. According to him, the vehicle was not part of the convoy. So now this vehicle came after the X5 BMW. He wanted permission from the VOC to see if your vehicle can come in.
And Your Worship, I'm not asking anybody a question because I know I'm not here to ask questions, but the question arises. Why didn't he say the car, because they say he doesn't have a problem with me, doesn't have a problem with accused number 2, but he didn't put any evidence here that he said, you guys can go in, the vehicle will have to go park on the other side. Yes, never said that, because he's got a problem with us. That's how it's done all the time. Inauguration of the president, opening of parliament, where the president is, they are designated areas for designated dignitaries. And if you don't have the vehicle registration, they said, you know, Mr. Malema, you can come, 2 of you can come, but the vehicle will have to go and park on the other side. He never said that. He just blocked the car. I went out deliberately, hoping that he will recognize me and say, no, it's okay. You go in, this vehicle must go back. Because, Your Worship, there were people who were entering, walking. They were not driving. He could have just said to us, join this, you go forward, let this car go and park on the other side. There was never such an argument. If anything, they say he was calling VOC. VOC for what?
To ask permission for your vehicle to enter, sir.
Okay, but because I've got the right to enter, why is he not saying I must enter?
He's talking about the vehicle.
But why am I being stopped? I'm also a vehicle now.
No.
I'm not a vehicle.
You
I'm
are
not
a
a
person.
vehicle. The argument, Your Worship, is he should have said, which he didn't say, Mr. Malema, Mr. Ndlozi, you guys can walk in, the vehicle must go and park at an area that is designated for vehicles that are not accredited. He couldn't say that because he knew we're rightfully there. But I want us to bear this in mind, that, and we must not lose this sight. Here is a vehicle that is not accredited, that has got no right to be there. It pushes through, it goes in, gets to park with president's vehicles, former president, heads of states, and then you sit there throughout your worship. No problem at all. The reason why these cars do go through security check is because you must not bomb those dignitaries. Now this car goes in, attends throughout the ceremony, and there's no problem, it finishes everything, it leaves. There's no way in the discipline of Presidential Protection Unit and VIP protection that a car that is not discredited and has not passed the security check, for a second, it can spend time with president's vehicles. Why? If if there's something wrong with it, Your Worship, why didn't they follow us up? Say, no, leave here, we're going to catch them inside. They didn't do that. Nothing happened.
Colonel approached the driver. When he testified, he went to the driver, informed and the driver said the leader of the EFF, named Malema, was inside the vehicle. He testified that is what the driver said. He said, I looked to the back of the vehicle and I did see Malema, Mr. Malema was inside the vehicle. I greeted Mr. Malema, he testified, and then informed Mr. Malema that the vehicle cannot enter. That is what he testified.
You never greeted me. Greeted me how? The first time me and him interacted was outside.
And he said that you were more than welcome to walk inside. That is what he said.
Who could have walked inside?
Yes.
We could. If he had said that, the way we were so eager to attend the funeral, we could have walked inside. We're not obsessed with vehicles. There's nothing special about that vehicle.
Yes, but
So-
he said that you can walk inside.
No, he didn't say that.
He did not say that.
No,
Okay.
he didn't say that.
And you, when he said that you are welcome to walk in, you said, I will not walk in, I will drive in. That's what Colonel Venter testified, you said.
That is his imagination.
Is that so? Okay. Your Worship, I'm just looking at the time. Can the court... I still
how
have,
many questions is
I still
there?
have a few questions, Your Worship, so I'm not sure.
I think we can still proceed until 2:45 at least, so let's see how far. Unless there's anything else in terms of administration work for the clerks.
I'm looking, but it did indicate to me, Your Worship, so I'm looking.
It's fine, 2:45?
Yeah.
Yes, I believe we should spend each and
Okay.
every minute to this case to get it finalized. Yes, you can be excused. Thank you. Thank you, Ms. Hart.
May I proceed, Your Worship?
Yes.
Thank you. He said that you can sit if you want to, sir.
No, I wanted to drink water.
Okay, okay, it's fine. Oh, you're done. He testified. He said, Colonel Venter then said that he moved to the front part of, or the front part or the side of the vehicle. He was standing with his back towards the vehicle. Is that so? Do you-
The front.
the
He was like this.
so his front was facing
The chest
the
was
vehicle.
on the windscreen.
Oh, was his whole body lying with his hands open?
Yeah,
Oh,
like
with
in-
his
like in
chest on the.
Yeah.
Can I just get clarity? That is not on the video.
No.
So that have happened prior to what we have
Yes,
seen.
Your Worship, what you see here is when now we're pushing him away.
Yes.
But we had spent a lot of time outside the camera. So where you are starting to see us is where we're pushing, but where is blocking the car
It's
or
not
even
on-
stopping the car, you can't see. It's not on the video, conveniently.
Your Worship, let me continue.
Yes.
Thank you, Worship. So let me understand you correctly now. His hands is stretched out.
Yes.
And his chest, his body, his upper body is literally lying on the vehicle of your vehicle.
Yes.
Okay.
That's why I used the word that he was possessed.
Possessed.
Yeah, because I've never been in dealing with police for a very long time. I've never seen a policeman behave like that. You know, if anything, he will try take a cone, put in front of the vehicle so that you don't go past. They'd never block a car with their body. There's always a mechanism. One of such mechanisms is to put a cone, or alternatively, you close the gate.
Okay. And possibly you can ask his senior what is going on questioning the vehicle, there's another option. You can ask a senior, like you wanted to call Vok. What I'm saying is he could also maybe speak to his senior to inquire about the vehicle that you were in. That's also a possibility.
You don't talk to your senior on your own. Isn't it you must say to us, guys, you wait here, let me call my senior, Vok, to check if you must come in or not. He never said that to us. I'm just saying, Your Worship, you come to a car, who's in this car? No, Julius Malema. The next thing, you go on radio, you're calling Vok without telling these people I'm calling Vok. The decency would be, okay, there's a problem with your vehicle, let me call Vok or something like that. He never said that.
But he testified, sir. He said, I will first get permission from Vok. He said he wants to, but he was speaking to the driver.
No, I would have picked it up. Remember that the reason I got out first was for him to recognize me. Because at the back of my mind, once he sees it's me, then he'll realize he's making a mistake. It looks like once he saw me, he became more agitated.
But he recognized you when you were in the vehicle, because the driver said, I'm driving the leader of the EFF. So he recognized you. No, you can't
recognize me. So Viano is like this. The driver is there, and I'm at the back. So for you to recognize me in the Viano, you have to put your head inside the car, and then you will see me at the back. So to say you recognized me in a Viano, not even from the windscreen in front, Your Worship, because it's tinted. So when you look at it from the front, it's all dark inside. And then when you are talking from the driver's side, you can't see who's at the back. I know this because all the time they ask, who are you driving? They say Julius Malema. Then they start putting their heads inside, wanting to see who's inside the car. So he didn't do that. He didn't recognize me. That's why I said, let me go outside and speak to him. My hope was that he will recognize me and realize he's making a mistake.
But sir, he did testify in court, and he said, I did look through to the back of the vehicle, and I did see that Mr. Malema was inside the vehicle. I greeted Mr. Malema. He said, I did look to the back of the vehicle. He recognized you.
I dispute that because he doesn't even remember how many people were in the vehicle, by the way.
You dispute that? Okay.
Remember, he said there were 3 people.
He said there was 3 people, and Officer Mpisa also just noted 3 people in the vehicle.
And
that's not correct, Officer Mpisa didn't know how many people in the vehicle. I can give you the reference.
As response?
Your Worship, I am in disagreement, Your Worship. He did say that there were 3 people that he saw in the vehicle, Your Worship.
The court will allow it for later, or will rule on it at a later stage after confirming so.
Thank you, Your Worship.
Not delaying the proceedings any further, I will allow you to ask the question. But if the court has confirmed that you are not correct, such question and answer will be deleted from the record. You may proceed.
Your Worship, it is not in dispute that there was a bodyguard. It is actually brought to the attention of the court by them that a person who appears like Malema's bodyguard then came out. Then how can they be Malema's bodyguard and be the driver and be Ndlozi and be Malema and then remain 3? And from how it works, generally is the driver and the bodyguard. So it doesn't work like that. It is you who brought it to the attention of this court. You even asked me a question now. Is this the bodyguard? So if there was a bodyguard and then there was a driver, then there was the 2 of us. I know I'm very bad with mathematics, but we are 4 already.
Oh, you're 4, okay.
So the reference, just from our learned friend to check this, he disagreed with me, is the transcript of the 7th of April 2022, page 49. It's my footnote number 202 in my heads of argument.
Thank you.
Your Worship, I will check Your Worship, because I am of the opinion that he said there was 3. I will check that later, Your Worship,
Yes,
just
you
for
may do so.
the sake of progress, Your Worship.
Yes.
There was a lady officer, remember the 2 female officers that was following the 2 of you when you were pushing Colonel Venter? Then there came a 3rd person that was standing with Colonel Venter, a 3rd person.
Yes.
Okay. Do you know who that person?
I don't know them. All 3 of them, I don't know them.
You don't know who that person is. That person is General Zulu.
Yes.
Okay. Colonel Venter testified that the General Zulu said, leave, leave. Did you hear that from General Zulu? Did you hear she said that?
But in that video, you can see the lady who came 3rd is actually standing by the guardhouse with Venter, and I'm on the other side. It was impossible for me to hear leave, leave.
You didn't hear? Okay. I'm going to ask you about the VOC. Did you know that on this specific day, on the day of the incident, that there was a VOC? Did you know that? On this day only?
I wouldn't know what is a VOG if it's not explained in full, Your Worship, because I don't want to agree to things I don't understand.
Colonel Venter explains the Venue Operation Center. He said he wanted to get permission from the VOC. It's his seniors who is on the VOC. My question is, did you know about the VOC on the day of the incident?
No, not at all.
Okay. You heard Colonel Venter testify that he did not see any visible permit on the vehicle. And he said that he would have still stopped the vehicle because it wasn't part of the convoy.
I had that.
And you agree with me, you came after the X5?
Yes. There is no convoy that says if you come after X5, you're not part of the convoy.
Pleases the court, Your Worship. At this point, I've got no questions for the witness, Your Worship.
You sure? No further questions?
No further questions at this time.
Okay, just before I allow re-examination, I believe Ms. Hart indicated that she does not have any further question, but we are still left with the issue that the court needs to rule on what the state have said. So if I don't rule at this stage, it will then not be procedural to allow re-examination. So the court will rule on that statement, which has been put, and the question was with relationship to how many people was in the vehicle, whether there was 3 or 4 people. That was also the questions which was put to Mr. Mapisa in this regard. And at first, Mr. Mapisa's answer was to the aspect that there was 1 or 2 people plus the driver in the vehicle. And then it was further put by Mr. Holders that there was 4 people, and his answer was, I cannot dispute that.
Yes,
So
yes.
he cannot remember, and therefore the court will not allow that question to 4 people was in the vehicle to stand. The court will rule. So, Mr. Ouders, you may proceed with re-examination.
Thank you, Worship. That reduces it to only 2 issues that I have, if I may, Your Worship. Mr. Malema, you were asked now about the VOC. What I want to put you in, which is in part of the argument, is that Mr. or Colonel Bronkhorst testified, and he said as follows. I just want to give you the references so that there can be no dispute about it. He testified that on the day in question, and I just want to give you the position that he held. He was the acting section head for incident management at the Protection and Security Services at the SAPS. And on the record, page 74, dated 9th of March 2021, he said that he was in the VOC, the Venue Operational Center. And the important aspect that I want to put to you, sir, is that he testified, he conceded on the cross-examination that being at the VOC, he hadn't heard from the complainant until 17:15, even though this incident had taken place at 15:44. Your Worship, the reference is transcript, 9th of March 2021, pages 128 and 129, in my heads of argument, paragraph 31.23. So now, we know the incident took place, as we see on the video, at 15:44. Colonel Bronco said he never heard from Colonel Venter until 17:15. Do you have any comments, sir?
Well, Your Worship, it makes that point of him being on the radio when he was talking to us, being on radio and communicating with folk. That argument falls off. Because if he was on the radio talking to folk during our time, it will be exactly around this time. So now his own colleagues say he has never called, we didn't hear from him until after 5 o'clock. So, and it confirms my version that he has never been on any radio. He has not been attempting to do anything. If anything, he was acting like a person who's possessed and completely out of profession.
My last aspect, so I'm going to ask you to watch the videos my learned friend did, but I'm going to ask you, because it's difficult to focus on everything, focus on the 3 police ladies in uniform.
Yes.
And then my question after the video will be, who are they holding back, you or the complainant? Will you please watch? For the record, you see the vehicles arriving. You can see the one police lady on the right-hand side of the screen at the moment.
And for the record, they do not have blue lights. Many of those who passed, only these ones have blue lights. No blue lights.
For the record, the front ones have blue lights, and then the
Yes.
stream of vehicles that don't.
No blue lights.
Right. Well, if you just... No, no, it's on the fast.
And for the record, Your Worship, blue lights does not mean accreditation. Even ministers on that day had to be accredited. That's why some of them went to the stadium through shuttle. They had to park somewhere and get into a bus. Yet they've got blue lights. So blue lights does not mean accreditation.
see the vehicles arriving. You see the police lady on the right-hand side in a blue uniform. And 15:45. So the last aspect. There's the other police lady arriving also to the right-hand side. Do you confirm?
Yes.
Right. Now, in the confrontation, I want you to see whom they hold back. You, Colonel Venter, or anybody else? Come to 2 X5s.
And it should be noted, Lawrence, that before these 2 X5s, there was a minute's gap, seconds gap between the car, the last car, and these ones. And then they came in, bumper to bumper, these two, because they are driving together. And for the record, your worship, we are here. We're already here. We're being blocked. The reason why you are being told to look at minutes and count minutes and as if we're not part of the convoy, we came late outside the convoy, is not true. We're being blocked. We're here. If you check the outside camera now, you'll find us there.
But even on the inside, Mr. Malema, in which direction are the people looking?
They are looking at the direction, the outside direction, because there is an activity there.
But we don't know what they're seeing because
we don't see what's happening. But conveniently, the outside video is not brought to this court, so that the court cannot have a total picture of what really transpired and make a decision on half-baked information. We're here. Everybody is looking at outside there. So the story that your car came minutes after is neither here nor there, because I was blocked outside.
And 15:49:10. I want you to focus, please, sir, on, as my learned friend had asked you, on the ladies. You see them there coming into camera? They put their hands up. Are you watching them? 3 ladies. Thank you. Those 3 ladies, in that confrontation, whom do they approach and hold?
Venter.
Do any of them push you or accused number 2 back?
No.
Thank you.
But if you look at the Lawrence, Venter has got a radio there Your Worship, on that video when he's standing next to the guard house. He's not calling for backup. He's not calling vogue. Why would a police officer who feels under attack not call for backup, not call for vogue and say we've got an incident? If anything, he calls when we're done and we've left at the cemetery.
Thank you, Sir. When you observed Colonel Venter, what was he doing? Did he look perturbed? How would you describe?
No,
his
he was in good shape. If you play that video,
What?
he's continuing with his duties. He didn't have any problem. He was interacting
What's
with
his
people.
facial expressions?
He's even laughing. He says when he panics, he laughs or something. I remember he said something to that effect. He's laughing. He had access to all manner of assistance he needed if he was on the ride. He could have sanctioned any assistance. He knew, and for sure, even those police officers, the ladies, reminded him that what you are doing is wrong. Stop it.
And most significantly, do you see him summoning any backup or anybody to take
No.
action after the...
No. But also, in his own evidence, Your Worship never said we went inside to look for them or to look for a vehicle. My biggest problem, Your Worship, is as you are about to make your own decision, why would a car that is not credited, that is not security checked, pass and go and park with the president's cars and other cars that are security checked? What? Because it defeats the purpose. If a car is not checked and then some two tiny young boys come and push a well-built police officer, and on the basis of that, you say, no, that car can still park, even when it has not met the security requirements. He knew, and if he was honest, he was supposed to confess here. But after his investigation, he realized those people had a right to be there. So it's not an assault out of intention, Your Worship. We never left our homes to go and assault a police officer. It was never in our mind. In our mind was to bury our mother in a dignified manner. And we were not going to allow anything to take that away from us. From where I'm sitting, I feel justified that had I not done what I've done, till to date, I will not have a closed chapter because I will not have buried my mother out of the white arrogance of a police officer who think he can do as he wish. If we're wrong, Your Worship, why are these men and women in cloth, law enforcement officers, in uniform? Why are they not joining Venter? Why are they just standing like that? These are senior people. By the way, Your Worship, as a special funeral or a state funeral, the parade is constituted by very senior officers. They would have intervened there and there. Why would these people just sit like that, stand like that, if there are people who are committing crime? Unjustifiably so. They knew Venter was doing something wrong, and that's why they did not even intervene. They could have finished us. The one that Mapisa, who came to speak to accused number 2, came, spoke to accused number 2, encouraged him in his own ways to go back to a vehicle. How do you beg a criminal? Why would a soldier beg a criminal? He knew there was something wrong, and that's why he asked us to go back into our cars and proceed.
Thank you, Bishop. I have no further questions. Those are the only two aspects I wish to clarify. Thank you, sir.
Thank you, Mr. Otis. Thank you, Mr. Malema. You're excused. I believe that may be returned to Mr. Otis.
Bishop, it is my intention to call accused 2, but time is...
I believe we have run out of time. The court also wants to thank all court officials. I believe I said quarter 2, and we are over quarter 2 as well. I do thank all court officials in this regard. I believe I was approached off record with regards to a postponement date, which is the 1st of July. That still stands, is that correct?
Yes, Your Worship.
Thank you. Mr.
Friday,
Malema?
1 July, Your Worship.
Yes. Mr. Malema as well as Mr. Ndlozi, may stand. We have run out of court time and therefore this matter is now being postponed to the 1st of July 2022, court number 13 for further evidence. Both of you are on warning and warned to appear at 8:30. If you fail to be at court or to remain in attendance until you are excused by the court, it will lead the court to issue warrants for your arrest. Do you understand? Yes. You are then excused. Ms. Hart, may the USB, the video evidence be returned to court. The court will take possession.
Sorry.
The court has been placed in possession of the original charge sheet as well as all the exhibits. The court will remain in possession of such exhibits to prevent that it is not lost for future reference.
Mr. Baba is just assisting us to hand to Your Worship
Yes.
the memory stick. It's in the official envelope, Your Worship.
Thank you. Thank you, Mr. Otis. Thank you, Mr. Hart. Court adjourned.
I wanted to do that, but the security must bring the key for you. Can you tell one day? Yeah, to have, bring the machine.
One